Good morning and welcome to the February meeting or hearing by the Board of Oil, Gas and Mining. We will start our session with our normal briefing session, so if we could go ahead with the legislative update. Thank you. Or whatever.
Thank you, Chairman. Yeah. Thank you, Chairman, members of the board. Again, my name is Mick Thomas, Director of Oil, Gas and Mining. We're going to have a relatively brief briefing session this morning. I hope you all don't mind saving a little bit of time. But the first item on the agenda, on the briefing session agenda, is for Natasha is going to update us on legislative activities pertaining to the division and the board. Go ahead, Natasha.
Yes, I'm Natasha Balliff. I'm the Legislative and Planning Coordinator for the division. And like Mick said, this will be very brief. There's actually only two bills that I wanted to report on that directly impact the division. The first one is House Bill 419. This is environmental legal action amendments. If you remember last year, we did actually approach the legislature because I believe it was OSM. I feel like I get that wrong every time, but I believe it was OSM came back and said, this law that you've had in place for the last 14 years, it doesn't work for our rules anymore. So we went through, we changed the statute, and then they came back and we could go back to how the language was. So this bill, House Bill 419, is just undoing the changes that we did last year just to comply with federal regulations. That one has moved through the House and it's sitting on the Senate second reading calendar. That one has been moving relatively nicely through the session, and that's one that we anticipate passing. And the other, not even technically a bill, it's a resolution. It's Senate concurrent resolution regarding permitting of oil, gas, and mining. This is Senate Resolution 4, and this one just urges the division to put in place an MOU with us and the BLM so that we can help out with some permitting reviews for them. But that's really it. This has kind of been a light legislative session for bills that impact the division, but I'm happy to answer any questions if you have any.
I've got a quick question. So on the helping on the permitting with the BLM, is that just on oil and gas matters, or is it minerals as well?
That will be for the entire division.
Okay.
We'll have it work with both of our oil and gas and our mining programs. Did you have?
I do have just a slight update regarding that resolution that Ms. Balliff just talked about. The latest version has removed the term MOU and replaced it with cooperative agreement. Nuance. There's a lot of funny things regarding definitions at the feds, and we're trying to work around wherever we can. But generally, cooperative agreement is about as milquetoast as you can get, and so we're running with that. Just otherwise, what she said is correct. And as a reminder, we've briefed the board on that before. Our goal is to provide administrative support to the feds, specifically the BLM, for their processes. There's nothing about this resolution that changes any federal processes in any way. We're simply providing additional support for that. So thank you.
So as a former director of BLM,
Correct.
I remember, and I see John back there,
yeah.
We tried every different trick to try and figure out how we could work together, the feds and the states working together, because we love the states process. And we could never do that, and that's been, 15 years? So glad to hear that.
Persistence pays off. And seriously, your groundwork on that helped a lot. Believe me, it paid a difference. Thank you.
Okay.
Just a question on the primacy for the Class 6 wells. Have we heard any more on that?
Yeah, actually, I can update you. We've turned over the application. We did that in December. We've had a couple, we've gone back and forth a couple of times with the EPA, just cleaning up certain things. Right now, I'm just cleaning up a couple of dates that we had in our program description. Hopefully we have that turned back over by the end of the week. They did give us a time frame. I really wish I brought my sticky note that had it, but they're anticipating later this year, I think like summer fall time frame that we would get primacy.
Thank you.
Oh, wow.
Yeah.
Okay. Natasha, I really appreciate your written updates that you send us out every couple weeks, or every week, so.
Good. Good. I'm glad that it's
Thank you.
appreciated.
All right, go ahead, Mr. Thomas.
Sorry, a little bit of fun there. Next topic, update on oil and gas bonding rulemaking. The division recognized that there were technically substantive changes that needed to be made to the draft that entered into formal rulemaking. These are not structural changes. The math and the goals and the tiers are all the same. But technical substantive changes are if we change a definition for clarity, which is where probably the most significant statement things that we've done, those still count technically as substantive changes. As a result for that, we are finalized with the draft, and it went out yesterday. Thank you to stakeholders. Our new comment period will be March 15th through April 15th for additional comments from stakeholders, obviously. And just wanted to update the board on that. If you have any comments or questions or goals, since we are in a new comment period, it is the board's discretion how you want to handle that, what sort of comments you accept, and I invite discussion from the board on that matter.
Okay. Board, any questions of Mr. Thomas on this? Okay, so we have discussed this a bit in the board, and recognizing that our March docket is pretty light with two ironically, bonding forfeitures. And we're thinking that it would be appropriate at this point in time to have another public hearing, and that might be a great opportunity to do that. Anticipate that we could dispose of these bonding discussions on the March 25th hearing by about 10 o'clock, which would give us 2 hours or so for public hearing at that point in time. So we think we'd like to proceed that way. Anybody want to make comments on that on the board? Go ahead.
Do we have to publicly announce that? Does it have to go out as a notice that we're going to do that?
I can add that to the form that I submit to Office of Administrative Rules, so it would be posted in the Utah Bulletin. That is supposed to be like a public website people know about. I don't think a lot of people know about it, so I can also distribute it to the stakeholder list that I have and just have them reach out. I can have a list. I can keep a list for you guys.
I see a lot of the interested parties are here in the room, so hopefully we'll get good participation.
Yeah, I think we will. I know that there was a lot of people wanted to present on it in the last round. I think that it will be more appropriate to have it on the second round, so I think March will be a good time frame.
Okay.
Thank you.
Yeah, and we wouldn't necessarily be limited to the 2 minutes per party. We give people sufficient time to consolidate their thoughts, and time between now and March 25th. There's a whole month there for people to get their presentations together. Okay, so let's see to that then. That
Natasha,
it's widely distributed. So,
could you summarize the calendar moving forward on this?
Yes. So we informally sent out the rule edits last night to stakeholders. I believe everyone on the board should have gotten a copy of that as well. It will post in the Utah Bulletin starting on March 15th. That will indicate the comment period has opened. There is a 30-day minimum comment period, which has it closing on April 15th. And that gives us enough time to consider all the comments that we receive and then present it back to the board at our, I believe it's April 22nd board hearing. At that time, if the board does choose to accept all the changes and make the rule effective, we can either have the effective date start April 22nd, or we could push it out to May 1st. Within the R649-13 rule, I did update all of the dates to say May 1st, so that might be a good effective date for it. But yeah, that's kind of the time frame right now. We still do have time for additional changes if that does come up, but hopefully this is the last round.
okay.
Thank you. Any other questions regarding the oil and gas bond rules?
Seeing none? Go ahead.
Thank you. Briefly, just some other topics. Not a lot going on, but as some of you may know, the division has, and the Office of Energy Development and a number of other stakeholders have been highly engaged for some time on the critical mineral industry and developing that industry in Utah specifically. That is ongoing. I don't have substantive board-related topics other than there are a few bills going through the legislature right now that we are tracking about these topics. The latest one puts a permitting coordinator in the Governor's Office of Economic Development. The initial draft of that was somewhat ambiguous as to what this coordinator would do, as well as delineating the roles of gathering facilities, or pardon me, gathering lines between what DEQ does and what OGM does. We were able to make some changes there and clarify that those topics that are currently regulated by OGM and the board will continue to be regulated by OGM and the board. In addition, we were able to add language that clearly states that the Board of Oil and Gas and Mining cannot be held accountable to the Governor's Office of Economic Development. That was not the intent of the language initially, but we felt like it was appropriate to put some language in there to clearly define that the board is a protected, I wouldn't say sovereign entity, but I think you all get it. So we're tracking that bill. The division does support that bill as it moves through. So any questions on that, I'm happy to discuss.
Which committee is that moving through?
Oh, do you know? I don't know.
I think it's been going through the natural resource
Thank you.
committees.
Okay.
We have some of these bills. Normally, I would just say natural resource, but so they're in the energy, they're in public utilities. So there's a number of different committees that are tracking various things regarding critical minerals. Thank you, Natasha.
And do those have numbers? I mean, Senate bills or?
The latest one I think is 575. Is it House Bill 575? No. Okay, I'm wrong. Let Natasha talk.
Okay.
Yes, so there's critical mineral amendments. That is Senate Bill 254. There's also a resolution on it that I don't have on my list right now, so I can get that to you.
Thank you. With that, those are the others. Next month, agenda and division calendar, again, as we've said, the next meeting is on March 25th. Thankfully, it looks to be somewhat light. We'll try to keep it that way so that we can have good discussion regarding the comments on the bonding rules. And that's all I have to present. Any follow-up questions? Okay, thank you.
Okay, thank you. Thank you, Mr. Thomas. Thank you. Natasha? Okay. Okay, so at this time, we have an opportunity for public comment. So if anybody wants to make any public comments at this time to the board and division, you're welcome to step up. Seeing none, we'll go ahead and proceed with our first docket then. So the first docket item is, hold on a second. Okay, this one here is, this is the official one, right?
Yeah.
Okay. Okay, so the first docket item is a per acre bonding cost for small mines and exploration, and it's by the division.
Perfect.
So the division will present information about average cost per acre for reclamation, followed by an opportunity for public comment. Okay, could you guys please introduce yourselves to the board?
There. Can everybody hear? Okay. My name is Wayne Western. I am the program manager for the minerals program. In order, this is Brian Rue. He is an environmental scientist. Then Kim Colburn, also an environmental scientist, and what we informally refer to as the bonding czar. And then Bailey Jones is another environmental scientist. Before we proceed, are there any questions that the board has about the procedures?
Well, before you proceed, are you going to ask us to decide anything today? Or?
Yes.
Okay.
We will. We have the general procedure is that we are required to give a update on the bonding and procedures, and then we go through and update the costs on a yearly basis. We make recommendations to the board, and then the board has the opportunity to adjust those if they so see fit. And once they've been approved by the board, then we go into using those as our standard per acre costs for the year.
Okay. And what would be the timeline on when you're asking for that concurrence?
In the past, it's usually been done the same day.
Okay.
But we will defer to any decisions and timelines that the board has.
Okay. Go ahead and proceed then. Thank you.
Okay. So, Mr. Chairman, fellow members of the board, thank you for the opportunity that we have of presenting our reclamation surety costs for small mines and exploration projects for 2026. Give you a little background on this. We have two different methods of calculating bonds. One is a per acre cost. This has been very effective in the past because a lot of times the small operators don't have the technical expertise to develop a sophisticated reclamation cost. And even if they do, there's a lot of time that goes into it. So having a per acre cost has been very effective in the past. And when we've had to forfeit small mines in the past, we found that our per acre costs have been pretty much in line with what the reclamation costs are. There are some times that a small mine or exploration project will have something unique about it, or the operator wants to see if they can reduce costs. And we do allow for site-specific calculations that are either done by the division or verified by the division. And this is all outlined in our rules, R647-3-11-3, which came into effect in 2011. I do want to point out that the bonds are not fees, that the operator does get the money back once the reclamation has been insured, and we look at the bonding more as an insurance policy. Okay, the board has the prerogative to establish the per acre costs. The division gives a presentation to the board, and then the public has an opportunity for comment. I want to go over a little bit about the different costs that we have for small mines. We break them down into direct costs, indirect costs, and escalation. For the indirect costs, they're the things that people have to do the work. It's earthwork, revegetation, facility removal, and also for closing shafts, portals, drill holes, other things. There is always indirect talks that are involved, such as mob, demob. This can be very significant for some of the small sites. In some cases, just the cost of getting the equipment to from the site can be 50%. Contingency, as anybody that's ever done a home remodeling project knows, that things take longer and cost more, even when you go in and do the most diligent planning. Engineering redesign, we sometimes have to go in there and redesign the facilities, that what was on the ground is not what we originally was bonding for. Sometimes the operator's gone over, or they've done things that they were not authorized to do. So when it comes to reclamation, we have to revise the plans. There's always other expenses, the main office, what the support costs that we have, and also just our time to supervise the project. We do have an escalation factor in there, as unfortunately, as we all know, things cost more this year than they did last year, and so we do take account into that. Going over our indirect costs, the contingencies 10%, engineering redesign is usually low at around 2.5%, main office expense 6.8%, project management also low. So we come up with a total of around 22%. The MOB and DMOB is handled separately because, as I mentioned before, they can be a large part of a small mine operation.
Mm-hmm.
The books, references that we use, we've been using these for several years. They've been giving us excellent results. One is the Equipment Watch, commonly referred to as Blue Book. The other one is RS Means that we use for labor. And we've also are basing our approach on Tech Directive 7, which is what the coal program originally developed and has been being used for the past 30 years and has an excellent track record. I'll turn the time over to Brian Rue.
Thank you. When calculating the escalation factor each year, we take a look at the historical cost index as published in the RS Means Heavy Construction book. We take a look at the previous 5-year index values, and we plug it into a formula in order to determine what the average inflation has been over those past 5 years. Prior to 2020, we've identified that the January estimates that are published by RS Means were typically within 0.5% of the January actual that gets published later on in the spring. We ended up finding out that as a result of the COVID pandemic and other market uncertainties, the margin of error between the estimate and the actual increased all the way up to 6.09%, which led to some very skewed data that we were using for our inputs. As a result of identifying this, we've decided that the appropriate path forward is to keep the formula the same, but rather than using the January estimates, we will actually use the July actual published data so that we know that we're putting good numbers into the formula. Here you can see the calculated escalation factor that we've had for the past 6 years. Last year we had it at 4.22% per year. This year it would be 5.09% per year.
Going over the per acre amounts, we have different models set up, such as a mini mine, which is up to 2 acres. We have 5, 10, 15, and 20 acre model mines with ongoing evaluation of large mines with less than 50 acres of disturbance. We use similar equipment and productivity rates utilized for smaller large mines, and we use the same unit cost source utilized as for large mines. So going over what a mini mine bond is, it has none to minimal surface facilities with minimal removal or demolition as required, is up to 2 acres maximum, has a maximum 10-foot depth of disturbance, will utilize small equipment that can be hauled with a pickup truck, and for reclamation and excavator work that can be accomplished in 1 day. The calculated total cost is using unit costs, and the calculated per acre amount is from the total cost. For a model mine of 5 acres, we expect an excavator of 50 hours total to be needed for reclamation. There should be minimal surface facilities, which are calculated separately when required, and have no leach pads. For a 10-acre model mine, we are adding an additional dozer of 45 hours total, and again has minimal surface facilities and no leach pads. For the 15 acres, we expect a dozer of 30 hours, an excavator of 30 hours, and a truck of 30 hours, with minimal surface facilities and no leach pads. For the 20 acres, there's going to be a dozer of 30 hours, an excavator of 30 hours, a truck of 30 hours, and a loader of 30 hours, with minimal surface facilities and no leach pads. For the subsoil and topsoil haul distances, a minor distance of up to 10 acres is used, and the distance can grow up to 20 acres. The dozer is used for pushing materials short distances, the excavator is used for digging materials, and the truck is used for hauling soil and trash for the 11 to 15 acres, while a loader is used for loading soil for the 16 to 20 acres. The pickup truck is used for support, and we expect there to be equipment operators plus 1 laborer.
For the mobilization and demobilization costs, we integrate into our calculations an assumption for travel up to 50 miles to get to the site. We add additional surety in 50-mile increments. The further a site is from an operation, the more it's going to cost to get equipment out there. We assume that equipment is loaded onto flatbed trailers and hauled using semi-trucks, and that a bulldozer would be needed for any site that is greater than 5 acres in size, and then a pilot car would potentially be needed for moving the equipment. We've adopted the abandoned mine reclamation program's costs for portals and shafts at $2,000 per portal for a 36 square foot maximum, and $3,000 per shaft for a 6 foot maximum diameter. This is assuming that we will use a loader or excavator to block the openings shut so that the public cannot get into them. That's generally the cheapest option for sealing off a portal. So this is not the cost for installation of bat gates or anything of that nature. Any large or unusually shaped openings would need to be determined based upon site-specific conditions, and structure and equipment demolition and removal is added as a separate line item from the per acre costs. For revegetation, we recognize that once an operator has done the earthwork, we no longer need to hold $2,000 per acre, and therefore we assume that we may need to go back to the site to reseed. So therefore we use $600 per acre if an operator has already reseeded while conducting earthwork. In the event that the operator has to do seedbed preparation, like it has not been done prior, we assume $2,000 per acre because we need money in order to take equipment out there to do the earthwork.
Okay, I get the fun part of talking a whole bunch of numbers. So for our mini mine bond costs, I put on here the 1 year, the 3 year, and the 5 year. So the 1 year is meant for the exploration. It's just meant until the end of 2027. That's $5,000 an acre. the end of 2029, that will be $5,600 an acre. And after 5 years, or 2031, that will be $6,100 an acre. And that is meant so that we can increase with inflation for each year. That's what we're expecting. For exploration amounts, this is using the excavator. It's $9,500 for the first acre with $6,000 each additional acre. So this is that 1 year escalation because we expect exploration to change. When people are actively working the site, they are changing their plans all the time. So this only goes out 1 year until 2027. For our small mines, those are on a 3-year or 5-year basis, where operators can choose which rates to lock in. So for the small 5-acre mine, that first acre is $10,500 for the 3-year escalation, or $11,600 for the 5-year escalation till 2031. Each additional acre after that for the 3-year escalation is $6,600, or $7,300 for the 5-year escalation. You notice how these amounts are lower. We assume the equipment has already gotten to the site, and we don't need to mobilize that equipment twice. That's why the amounts are lower. That first acre includes mobilization and getting the equipment out to the site. All the way up into the 5 acres that Bailey went over, we are at $36,900 for the 3-year escalation, or $40,800 for the 5-year escalation. The 6-acre brings on that second piece of equipment, so we have additional demob included for that second piece. So at 3-year escalation, that's $51,200 or $56,600 for the 5-year escalation. Each additional acre is $9,200 for the 3-year, or $10,100 for the 5-year escalation. Going all the way up to 10 acres, that's $88,000 for the 3-year escalation, or $97,000 for the 5-year escalation. The 11th acre to 15-acre small mines adds the additional truck for hauling that makes it slightly more efficient. We're at $107,900 for the 3-year escalation, or $118,000 for the 5-year escalation. Each additional acre is slightly increased because you have more fuel being used on the per acre basis. So you have $10,300 for the 3-year escalation, or $11,400 an acre for the 5-year escalation. Going all the way up to 15 acres, we're at $149,100 for 2029, or $164,500 for the 2031 5-year escalation. And this is the last slide with numbers on it, I swear. We're at the 16-acre. This is when we have 4 pieces of equipment moving. We're at $174,200 for the 3-year escalation, or $192,200 for the 5-year escalation. On this per acre basis, it's increased to $12,100 for the 3-year, or $13,300 for the 5-year. These last numbers for the 20-acre small mine, that's as large as our small mines can go. It's $222,600 for the 3-year escalation, or $245,400 for the 5-year escalation. So that goes out to 2031. So in our methodologies, we're using the same estimates that we have in previous years. As Wayne has explained, we have found to be pretty accurate on these small mine terms. The same methodology is the same. The only thing that we have changed this year is that we're proposing to use actual inflation numbers instead of estimates. That will make our estimates a little bit more accurate. But as a result, the small mine costs have slightly increased from 2025 for these 2026 numbers. Believe it or not, our laborers want pay raises and slight increases like that. All increase $1, and that adds up. So what we're recommending right now to the board is to approve the per acre surety amounts for 2026 as presented until we propose the new amounts here next year in 2027. Is there any questions for us?
Go ahead.
Yeah, I have a few questions.
Yes.
I guess first one, like you said, there's the costs have gone up.
Mm-hmm.
Do you have a percentage of how they've increased in general? Do you have a certain percentage?
What we found is that they're very in line with the the inflation values. The reason why we use the RS means construction index is heavy equipment is very different from eggs. That's in the standard inflation index that you would see on the news. We do compare them every year, and I think Brian Rue had that open last time I saw on his computer. Yeah. These expert. Yeah. What we try to do is we try to take it on 5-year increments, because some years we have these larger bumps and other years we have smaller. In 2023, we had a 20% bump. So all of a sudden, that 1 year of 20% increase, averaged over 5 years, turned out to be more around the 5 or 6%. We can provide that to you at a later time, Mr. Galecki.
Okay, that was a curious question. The next one is that I assume, the bonding per acre, as you've calculated it for equipment and such, you use RS means and the Blue Book, but it's also based on historic or empirical data that you've had through the years?
Yes, that helps inform our model mine. So as Bailey was describing, we have assumed perfect mine for the 5 acre. What does it look like? Usually it's just a square. And we know mines are not squares, but it helps us to be able to do the productivity and how long it takes to get equipment from one side of the site to the other. We found that those tend to be pretty accurate. The only time they are not accurate is when something does not go according to plan. Like, for instance, I had a site that was permitted for 10 acres. They only disturbed 3 acres. So we only needed $20,000 to clean up the site versus the entire bond of over $50,000. So that's when those get off. But when you look at it on per acre basis, it's pretty accurate.
And then just 2 more questions.
Yeah.
And then the operator can submit their own costs if...
Yes. So we have sites that do that all the time, such as their regular conditions. I'm just thinking about the gilsonite mines that have a very unique footprint with how they go down and excavate. We can't use the standard portal or shaft calculation for that because it's so unique. Mm-hmm. And we do that all the times for like brine operations and things that do not fit the mold. But this tends to work for 90% of our mines that are very standard sand and gravel operations.
One last question, thanks.
Yes.
As far as these costs, how is this bonding relative to oil and gas bonding as far as their reclamation is concerned?
This is very different.
Yes.
That oil and gas, particularly with their deep wells and the plugging, has very different calculations. That we're fortunate that we do have Dustin Doucette with us to help with the brine wells. He does have expertise in that, and generally on deep wells, we would go for a site-specific cost rather than on a per acre, where a per acre could help on just general surface disturbance, because sometimes wells have minimal infrastructure involved. But like I said, generally anything that goes that deep, 10,000, 20,000 feet down, you need very specific costs that come with a lot of learned the hard way.
Yeah, I guess, right. Their reclamation costs are more underground as opposed to surface. I guess I was wondering more specifically as far as their surface costs, if they're comparable. But
yeah, generally they're going to be about the same.
okay, thank you.
Okay. Other questions on the board? Go ahead.
So do you bring, whenever you want to revise the costs, do you come before the board yearly with this, or?
Yes, it's in statute that every year we come before the board, give the presentation, and then it's up to the board to come up with the costs. Generally, in the past, the board has taken our recommendations, but the board does have the authority to override our costs and establish their own.
Okay, and then are the stakeholders ever involved in this, or is there a necessity for that?
Yes, everybody the public has the opportunity to speak at this time and express their concerns. In the past, I think there's only been one person that has voiced concerns, but the according to the legislation, that we do give the presentation to the board, and then the public has the opportunity to comment and raise concerns at this time.
And so just a general question, with the emphasis that's being put on critical minerals and Utah's position in having these, do you anticipate any increase in the next year or 2 or 3 of activity by small operators in regards to this?
Yes, we do. You're going to see increases in lithium production because of the nature. Some of them are going to be on less than 20 acres if they're doing strictly brine production. We see other things. Some uranium may be limited to 20 acres or less. So those would be the major ones. Copper is a major critical mineral in the state. We don't see any underground operations planned, so anything would be surface mining and would be greater than 20 acres. Same thing with gold or silver. Most of those operations are generally going to be surface and would be much larger than 20 acres.
Thank you. Wait.
Board, do we have any other questions? Do either of you have issues that you're concerned about? Mr. Church or Mr. Galecki? Okay. All right. If you guys could just stay where you are for a moment, we'll see.
Oh, excuse me. We would like to just have a general call for anyone in the audience that would have a concern.
Yeah, that's what
voice their concerns at this time.
So at this time, I'd like to see if there's anyone here in the audience or online that wants to make a public comment on any of the issues brought before the board today. If you would, please come on up to the right-hand side over here. Matt, do we have anybody online?
We do not have anybody online.
Okay. All right. Board, do you feel that we need to go out and deliberate, or could we entertain a motion as we sit here?
I think I'll make a motion.
Please do then, Mr. Galecki.
I'll make a motion that we follow the recommendations of staff and increase the bond cost per acre as presented.
Is there a second?
I'll second that.
All those in favor say aye.
Aye.
Any opposed? I see none. So I want to thank you all for your presentation, the details and professionalism that you bring to this, small, not small, but small minds thing. It's not a small detail, but it's a small mind. So thank you very much, and we'll move on with the next topic. Okay, so next agenda item, we're going to go to the hearing examiner proceedings, and the first one being docket number 2025-049, cause number 132.81. In the matter of the request of agency action of SM Energy Company for an order pooling all interests and including the compulsory pooling of the interests of certain non-consenting and unknown owners within a 1,920 acre or substantially equivalent drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River, Wasatch, Colton formations comprised of section 19, 30, 31, Township 2 South, Range 1 West, USM, Duchesne County, Utah. Take appearances. Mr. Mayo.
Thank you, Mr. Chair. Mitch Mayo of Lear & Lear, PLLC, on behalf of the petitioner, SM Energy Company. One note for the board, for the 4 SM pooling matters that we're going to discuss here in the next few minutes, the reservoir engineer witness is actually on a flight right now, headed here for the spacing hearing this afternoon. So he's not available to answer questions about the poolings right now. If that causes concern, we can delay these till the afternoon. If not, and you have questions for him, we can always rediscuss those questions during the afternoon session. So I just wanted to make everyone aware.
Okay, I think we've got a competent petroleum engineer here, so.
I think we'll be just fine. Thank you.
Okay, division?
Good morning, Mr. Chair, members of the board. My name is Nico Micheletti, Assistant Attorney General, and I am here on behalf of the division.
Okay. For the division?
Assistant Attorney General Gary White. I represent the hearing examiner in this proceeding, and the hearing examiner is Mr. John Baza.
Okay. Okay. Well, Mr. Baza, go ahead and proceed, please.
Okay. Thank you, Mr. Chairman and members of the board. It's good to see you all again. And as stated by Mr. White, my name is John Baza, previously retired from the state of Utah, and I acted as a hearing examiner for the board in this proceeding. The proceeding was conducted, the hearing examiner proceeding, on Wednesday, February 18th, 2026. The proceeding was held with an anchor position in this DNR building here in Salt Lake City. No member of the public nor any party other than the petitioner opposed the request for agency action or appeared at the hearing examination. During the proceeding, various sworn declarations and exhibits were admitted into evidence. Additionally, live testimony from expert witnesses was received. The Division of Oil, Gas, and Mining and I had an opportunity to cross-examine the witnesses presented on behalf of SM Energy Company. And I might say that this was my first experience in this case with 3-mile-long horizontal wells. I understand the board has had much evidence and testimony on that in the past, but it was my first experience with it. And I guess you're actually looking at even longer horizontals at this point. So pretty interesting stuff. After reviewing the request for agency action, the sworn declarations, and the admitted exhibits, and hearing the live testimony presented at the hearing, I found and recommend the following. SM Energy provided sufficient and adequate notice of opportunity to the parties it was seeking to compulsory pool. Proper notice for the hearing examiner proceeding was also provided. Certain named owners failed to timely participate in the subject wells and should therefore be considered non-consenting parties. The proposed JOA includes terms that are just and reasonable, and it should therefore be adopted to govern future dealings between the parties. The 300% non-consent penalty is fair and justified, given the economic and geologic conditions present in connection with the drilling of these wells. I therefore recommend that the 300% non-consent penalty be imposed as requested. And finally, SM Energy has met its burden of proof and otherwise satisfied all legal requirements to compulsory pool the non-consenting parties. Counsel for SM Energy prepared proposed findings of fact, conclusions of law, and an order granting the request for agency action. I have reviewed that draft, but have not yet executed the final document. And I believe the division has also reviewed that and has not issued any objections to that. It should be ready now for both my signature and the board signature at this point.
Yes, Mr. Baza. What percentage of ownership is being force pooled?
Oh, goodness. Mineral owners being compulsory pooled looks like 0.144397%. Obviously a very small amount. So over 99% were voluntarily pooled.
Thank you very much.
Yes, the division filed a notice of non-opposition to the petitioner's request on February 9th. It maintained that position throughout the hearing examiner proceedings in front of Mr. Baza and it also maintains that position now. The division believes that the petitioner has met the statutory and regulatory requirements for a compulsory pooling order and has no opposition to the board issuing that order today. Thank you.
Mr. Chair, your mic's on mute.
Mr. Mayo?
Yes, thank you. Nothing to add except for our appreciation for the board and hearing examiner continuing this matter a couple of months in advance of the hearing, and also for the efforts in getting the hearing done. But on the substance of the matter, nothing to add.
Okay, thank you. Mr. White, I think we probably ought to see if you've got anything to say, too.
Wow, I'm at a loss for words for the first time in my life. I agree that everything looks good here, and that the hearing examiner reviewed the materials and conducted the hearing as it should have been conducted. I think there's a good record here, and that this is ready for the board's signature and granting.
Okay, thank you. Okay, board, any other questions or issues you want to bring up at this time? Okay. Anybody feel we need to deliberate? Okay, we'll entertain a motion to approve the request for agency action.
I move that we accept and approve this request, or confirm the hearing examiner's conclusions and confirm this request for agency action.
I second the motion.
It's been first and seconded. All those in favor say aye.
Aye.
Any opposed, say nay. It's unanimous, so the request for agency action is approved. Thank you. Okay, we'll go right on to agenda number 3. Looks like you guys are all staying put. All right. Agenda number 3 is docket number 2025-050, cause number 132-82. In the matter of the request for agency action of SM Energy Company for an order pooling all interests and including the compulsory pooling of the interests of certain non-consenting and unknown owners within a 1,280 acre or substantially equivalent drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River, Wasatch, Colton formations, comprised of sections 30 and 31, Township 2 South, Range 1 West, USM, Duchesne County, Utah. We'll take appearances. Mr. Mayo.
Thank you, Mr. Chair. Mitch Mayo again of Lear & Lear, PLLC, on behalf of the petitioner, SM Energy.
Thank you.
Nico Micheletti, Assistant Attorney General, on behalf of the division.
Okay. Mr. White.
Assistant Attorney General Gary White on behalf of the hearing examiner, John Baza.
Okay. Okay. Go ahead and proceed, Mr. Baza.
Again, Mr. Chairman and Board, thanks for the opportunity to present. Appreciate being here. I acted as the hearing examiner in this proceeding as well, which was held on Wednesday, February 18th, 2026. Again, it was held here in the DNR building in Salt Lake City. No member of the public nor any party opposed the request for agency action or appeared, other than the petitioner, of course, at the hearing examination. During the proceeding, various sworn declarations and exhibits were admitted into evidence. Additionally, live testimony from the expert witnesses was received, and the Division of Oil, Gas, and Mining and I had an opportunity to cross-examine the witnesses presented on behalf of SM Energy Company. This particular matter is for 2-mile laterals or 2-mile horizontal wells, and it actually overlaps the same acreage that we discussed in just the previous matter. For your information, the percentage of mineral owners being compulsory pooled in this case is 0.216282%. Again, over 99% of the area was voluntarily pooled. After reviewing the request for agency action, the sworn declarations, and the admitted exhibits, and hearing the live testimony presented at the hearing, I found and recommend the following. SM Energy provided sufficient and adequate notice of opportunity to the parties it was seeking to compulsory pool. Proper notice for the hearing examiner proceeding was also provided. Certain named owners failed to timely participate in the subject wells and should therefore be considered non-consenting parties. The proposed JOA includes terms that are just and reasonable, and it should therefore be adopted to govern the future dealings between the parties. The 300% non-consent penalty is fair and justified given the economic and geologic conditions present in connection with the drilling of these wells. I therefore recommend that the 300% non-consent penalty be imposed as requested. And finally, SM Energy met its burden of proof and otherwise satisfied all legal requirements to compulsory pool the non-consenting parties. Counsel for SM Energy prepared the proposed findings of fact, conclusions of law, and an order granting its request for agency action. I've reviewed that draft, and again, it should be ready for both my execution and the board's execution this morning. That's my presentation.
On February 9th, the division filed a notice of non-opposition to the petitioner's request for agency action. It maintained that position throughout the hearing examiner process in front of Mr. Baza, and it maintains that position today. The division believes that the petitioner has met the statutory and regulatory requirements for a compulsory pooling order and does not oppose the board issuing one today. Thank you.
Yeah, nothing to add except before Mr. Baza leaves, it's nice having him back here, and we appreciate him serving as hearing examiner in this. Thanks.
Mr. Chair, your mic is muted still.
Okay. Okay. Mr. White?
As with the prior proceeding, the hearing examiner proceeding was conducted fairly with due process. I feel that the evidence was appropriate and that the recommendations made by the hearing examiner should be followed by the board.
Okay, thank you. Okay, board, any other questions? Any deliberation? I seeing none, call for motion.
I'll make a motion that we approve the request for agency action as suggested by the hearing examiner.
Second? Motion's been made and seconded to approve the hearing examiner's findings. All those in favor say aye.
Aye.
Any opposed? It's also unanimous. Okay, so why don't we go ahead and take care of those right now, Mr. Baza? Okay, so we'll sign these orders and then we'll move on to agenda number 4, if anybody needs to shift around. We'll just take those up here. Thank you, John. Appreciate it. Good to see you. Okay, we'll go on to agenda item number 4, which is docket number 2026-009, cause number 132-83. In the matter of the request for agency action of SM Energy Company for an order pooling all interests, including the compulsory pooling of the interests of certain non-consenting and unknown owners within a 1,200 acre or substantially equivalent drilling unit established for the production of oil, gas, and associated hydrocarbons from the lower Green River, Wasatch, Colton formations, comprised of sections 29 and 32, Township 2 South, Range 1 West, USM, Duchesne County, Utah. Take appearances. Mr. Mayo.
Thank you, Mr. Chair. Again, Mitch Mayo of Lear & Lear PLC on behalf of the petitioner, SM Energy Company.
Yep. Ms. Division.
Thank you, Mr. Chair. Nico Micheletti, Assistant Attorney General, on behalf of the division.
Okay. Mr. White.
Assistant Attorney General Gary White on behalf of the hearing examiner, John Rogers.
Okay. Mr. Rogers, go ahead and proceed.
Thank you. Good morning, Chairman Walker and members of the board. My name is John Rogers, and I'm Environmental Manager with the Division of Oil, Gas, and Mining. I act as a hearing examiner in this proceeding as directed by this board. A hearing examiner proceeding was conducted in this matter on Wednesday, February 18th, 2026, for the matter as described by Chairman Walker just now. The proceeding was held with an anchor position Department of Natural Resources building in Salt Lake City, Utah. No member of the public participated in the hearing. At the hearing, Mr. Nico Micheletti represented the division and Gary White represented me, both from the Attorney General's office. Mr. Mitch Mayo represented SM Energy at the hearing. During the proceeding, 2 sworn declarations and exhibits were admitted into evidence from Mr. Levi Dean, a senior landman, and Mr. Brad Peterson, the Utah Region Asset Manager, both from SM Energy. Both of SM Energy's witnesses were accepted by me and the division as expert witnesses in their field for this matter. They also presented live testimony electronically at the hearing. On February 9th, 2026, the division filed a notice of non-opposition response to SM Energy resource request for agency action, expressing non-opposition to the granting of the request. At the conclusion of the hearing, Mr. Micheletti, on behalf of the division, stated support for the request for agency action. No other party filed a response to the request or appeared or participated in the hearing, therefore failed to timely reply or appear at the hearing after given proper notice. The Division of Oil, Gas, and Mining and I had the opportunity to cross-examine the witnesses presented on the behalf of SM Energy. After reviewing the request for agency action, the sworn declarations and admitted evidence and exhibits, in live testimony presented at the hearing, I found and recommended the following. SM Energy Resources provided sufficient and adequate notice of opportunity to participate to the parties that was seeking to compulsory pool. Proper notice of the hearing examiner's proceeding was also provided. Those compulsory pooled owners failed to timely participate and should therefore be considered non-consenting parties. The proposed JOA includes terms that are just and reasonable, and it should therefore be adopted to govern the future dealings between the parties. The requested 300% non-consent penalty is fair and justified given the economic and geological conditions present in the connection with the drilling of these wells. I therefore recommend that the 300% non-consent penalty be imposed as requested. SM Energy has met its burden of proof and otherwise satisfied all legal requirements to compulsory pool the non-consenting parties. For your interest, SM Energy has approximately 78.12% working interest in the Anchorman unit. Combined with those that have agreed to participate or otherwise voluntarily join the unit equals approximately 98.98%. The request seeks a compulsory pool approximately 1.02% of the mineral owners. The average weighted land fee owner royalty interest is approximately 16.99%. SM's Energy Counsel, Mr. Micheletti, prepared the findings of fact, conclusions of law, and order granting its request for agency action. Both the division and I have reviewed and approved the proposed order. It should now be ready for the board's review and execution. I'll take any questions at this time.
Board, any questions of Mr. Rogers? Seeing no questions, Mr. Micheletti?
On February 9th, the division filed a notice of non-opposition to the petitioner's request for agency action. It maintained that position throughout this process. The division believes that the petitioner has met the statutory and regulatory requirements for a compulsory pooling order, and ultimately the division does not oppose the board issuing that order today. Thank you.
Okay. Mr. Mayo?
Nothing of substance to add, Mr. Chairman. Thank you.
Mr. White?
Similar to the other proceedings, this was done in orderly fashion with due process and proper notice to the public. I think the hearing examiner's recommendation should be adopted by the board.
Okay, thank you. Board, any questions before we?
Can I just add one more thing?
You may.
I wish to apologize to Mr. Micheletti and Mr. Mayo. I reversed them there. Mr. Mayo prepared the order, so I'm sorry I mixed that up. Maybe no one caught that, but I did, so I apologize.
I did, yeah. I figured we'd let it slide. But yes, we prepared the draft order and have got it circulated. Mr. Micheletti's not responsible for any typos that are in there. Those are mine.
Okay, thank you. Okay, again, board, any questions before we, okay, any need for deliberation? Entertain a motion to approve. Go ahead.
I move that we approve the request for agency action as presented by the hearing examiner.
I second.
The motion's been made and seconded to approve the request for agency action. All those in favor say aye.
Aye.
Any opposed, say nay. Hearing that, it is unanimous. Thank you, Mr. Rogers, and we'll move on to item number 5. Thank you. Agenda item number 5 is docket number 2026-12, cause number 132-84, in the matter of the request for agency action of 4 Point Resources, LLC, for an order pooling interests, including the compulsory pooling of the interests of certain non-consenting owners in the Aldrin 13-7, 4-4-13-14-7H well, identified herein, in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River Wasatch formations, comprised of all of the sections 13 and 14, Township 4 South, Range 4 West, USM, Duchesne County, Utah. We'll take appearances. Mr. Mayo?
Thank you, Mr. Chair. Mitch Mayo of Lear & Lear PLLC on behalf of the petitioner 4 Point Resources. And actually with me today, although the board has permitted electronic participation, Mr. Phil Musial, the landman for 4 Point, we filed this initially to appear before the board and present this before the board, and were directed to the hearing examiner. But because it's his first time before the board, we wanted to bring him out, introduce you guys, and have a chance for you to ask him questions to his face.
All right. Thank you for coming over, Mr. Musial.
Thank you guys for hosting me. And Phil Musial, landman, 4 Point Resources.
Okay, make sure I get that right. Musial?
Musial, yes, sir.
Thank you. Sorry. Yeah. All right. We'll probably need to swear you in, I think, then. Is that right?
Oh, yeah.
To the extent you want to take testimony from him, absolutely.
Let's just do it.
Yeah.
Okay. Also, before I swear him in, I also wanted to disclose that my family has mineral interest in this unit, and just wanted to disclose that and make sure that everyone was okay with me participating
I'll get
in
that.
this.
Yeah, no objection from us.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining, and no objection from the division either.
Okay, thank you.
Assistant Attorney General Gary White for the hearing examiner John Rogers.
Okay.
Would you please raise your right hand to the square? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you.
Okay. Mr. Rogers, please.
Thank you. Good morning, Chairman Walker and members of the board. My name is John Rogers, and I'm Environmental Manager for the Division of Oil, Gas, and Mining, and I acted as the hearing examiner at this proceeding as directed by this board. A hearing examiner proceeding was conducted in this matter on Wednesday, February 18, 2026, as described by Chairman Walker. The proceeding was held as an anchor position at the Department of Natural Resources building in Salt Lake City, Utah. No member of the public participated in the hearing. At the hearing, Mr. Andrew Haynes represented the division, and Gary White represented me, both from the Utah Attorney General's office. Mr. Mitch Mayo represented 4 Point Resources at the hearing. During the proceeding, 2 sworn declarations and exhibits were admitted into evidence from Mr. Phil Musial, a landman, and Mr. Brent Kovac, a senior reservoir engineer, both for 4 Point Energy. Both 4 Point witnesses were accepted as me and the division as expert witnesses in their field of work in this matter. They also presented live testimony electronically at the hearing. On February 10th, 2026, the division filed a notice of non-opposition response to 4 Point Resources' request for agency action, expressing non-opposition to the granting of this request. At the conclusion of the hearing, Mr. Haynes, on behalf of the division, stated support for the request for agency action. No other party filed a response to the RAA or appeared or participated in the hearing, and therefore failed to timely reply or appear at the hearing given proper notice. The Division of Oil, Gas, and Mining, I had the opportunity to cross-examine the witnesses and presented on behalf of 4 Point Resources. After reviewing the request for agency actions, the sworn declarations, and admitted exhibits, and hearing the live testimony presented at the hearing, I found and recommend the following. 4 Point Resources provided sufficient and adequate notice of opportunity to the parties it was seeking to compulsory pool. Proper notice for the hearing examiner proceeding was also provided. Those compulsory pooled owners failed to timely participate and should therefore be considered non-consenting parties. The proposed JOA includes terms that are just and reasonable and it should therefore be adopted that would govern the future dealings between the parties. The requested 300 non-consent penalty is fair and justified given the geological and economic conditions present in the drilling of these wells. I therefore recommend the 300% non-consent penalty be imposed as requested. 4 Point Resources has met its burden of proof and otherwise satisfied all legal requirements to compulsory pull the non-consenting parties. For your interest, Tracy Lee Markham Sherrill was named to be pulled for failure to make timely election to lease or participate with a mineral interest. Shortly before the hearing in this cause, 4 Point received a signed election from Ms. Sherrill, voluntarily committing to her interest to the subject unit. Accordingly, Ms. Sherrill is no longer subject to compulsory pooling and has been removed from the request. With this small change, 4 Point has approximately 88.30% working interest in the Anchorman unit, combined with those that have agreed to participate or otherwise voluntarily join the unit, equals approximately 98.16%. The request seeks to compulsory pull approximately 1.84% of the mineral owners. The average weighted land owner royalty interest is approximately 18.48%. 4 Point Resources Counsel, Mr. Mayo, prepared the proposed findings of fact, conclusions of law, and order granting its request for the agency action. Both the division and I have reviewed and approved the proposed order. It should now be ready for the board's review and execution. I'll take any questions at this time.
Board, any questions of Mr. Rogers? Okay, I don't see any questions of Mr. Rogers. So, Mr. Haynes?
Yeah, thank you. The division appreciates Mr. Rogers' report. The division has also reviewed the proposed order and approves of it. Thank you.
Thank you. Mr. Mayo?
Just one slight clarification from what Mr. Rogers said. I think he inadvertently referenced the Anchorman unit from the prior cause. This is the Aldrin well, Aldrin unit. Just a clarification for the record.
Okay.
No, you're 2 for 2.
Okay. Board, do you have any questions? Okay. Mr. Musial, since you came all the way over here, why don't you take a minute to introduce yourself to the board and the audience?
Phil Musial. I've been with 4 Point for about 10 years now. Prior to that, I was a division order analyst with Noble Energy. I did a little work as a title attorney for a while out in Denver. So background in kind of both sides of land and land admin, and just made a landman by 4 Point pretty recently, and looking forward to getting to know you all better and working with you guys in the future.
Okay. So you're an attorney by training then?
Yes, sir.
Okay, thank you. All right. Anybody got questions of Mr. Musial? Okay. Board, do you feel any need to deliberate? Oh, I'm sorry. Mr. White, you got anything further?
I don't. I just want to state on the record that Mr. Rogers is doing a great job as a hearing examiner.
Okay, thank you. Yeah, being very efficient today, yeah. Okay. Now, do we have a need for deliberation by the board? I entertain a motion.
I move that we approve the request for agency action as presented by the hearing examiner.
I second.
Okay, the motion's been made and seconded that we approve the request for agency action. All those in favor say aye.
Aye.
All those opposed say nay. Hearing none, that is unanimous, so the request for agency action is approved. We'll take care of the paperwork after this next one. Okay. All right, so we will, yes, sir.
Thank you. Mr. Musial's done, so his brief
Okay.
appearance before the board is over.
Well, thank you for coming over, Mr. Musial.
Thank you.
All right, so we're gonna go ahead and proceed with agenda number 6, and then we'll probably take a short break to take care of paperwork and stuff like that. So, okay, docket number 2026-014, cause number 132-85, in the matter of the request for agency action of SM Energy Company for an order pooling all interests, including the compulsory pooling of the interests of certain non-consenting and unknown owners within a 2,560 acre or substantially equivalent drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River Wasatch Colton Formation, comprised of sections 29, 30, 31, and 32, Township 2 South, Range 1 West, USM Duchesne County, Utah. We'll take appearances. Mr. Mayo.
Thank you, Mr. Walker. Mr. Chair, Mitch Mayo of Lear & Lear PLLC on behalf of the petitioner, SM Energy Company.
Okay. Division?
Thank you. Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Okay.
Assistant Attorney General Gary White on behalf of the hearing examiner John Rogers.
Okay. Go ahead, Mr. Rogers.
Okay, thank you. Once again, I am John Rogers, Environmental Manager for the Division of Oil, Gas, and Mining, and I acted as a hearing examiner in the proceeding as described by this board, as directed by this board. A hearing examiner proceeding was conducted on this matter Wednesday, February 18th, 2026, for the matters described by Chairman Walker. The proceeding was held in an anchor position in the Natural Resource Building in Salt Lake City, Utah. No member of the public participated in the hearing. At the hearing, Mr. Andrew Haynes represented the division, and Gary White represented me, both from the Utah Attorney General's office. Mr. Mitch Mayo represented SM Energy at the hearing. During the proceeding, 2 sworn declarations and exhibits were admitted into evidence from Mr. Levi Dean, a senior landman, and Mr. Brad Peterson, a Utah Region asset manager, both from SM Energy. Both of SM Energy witnesses were accepted by me and the division as expert witnesses in their field and work for this matter. They also presented live testimony electronically at the hearing. On February 10th, 2026, the division filed a notice of non-opposition response to SM Energy's resource request for agency action, expressing non-opposition to the granting of the request. At the conclusion of the hearing, Mr. Haynes, on behalf of the division, stated support for the request for agency action. No other party filed a response to the RRA or appeared or participated in the hearing, and therefore failed to timely reply or participate at the hearing as for giving proper notice. The Division of Oil, Gas, and Mining had opportunity to cross-examine the witnesses presented on behalf of SM. After reviewing the request for agency action, the sworn declarations, admitted exhibits, and hearing live testimony presented at the hearing, I found and recommend the following. SM Energy Resources provided sufficient and adequate notice of opportunity to participate, opportunity for the parties that was seeking to compulsory pool. Proper notice for the hearing examiner proceedings was also provided. Those compulsory pooled owners failed to timely participate and should therefore be considered non-consenting parties. The proposed JOA includes terms that are just and reasonable, and it should therefore be adopted to govern the future dealings between the parties. The requested 300% non-consent penalty is fair and justified given the economic and geological conditions present in the drilling of these wells. I therefore recommend that the 300% non-consent penalty be imposed as requested. SM Energy has met its burden of proof and otherwise satisfied all legal requirements, compulsory pulled the non-consenting parties. For your interest, the working interest owners, SM Energy has approximately 76.84 working interest in the Austin Anchor unit, combined with those who have agreed to participate otherwise voluntarily join the unit equals 99.38%. The request seeks to compulsory pool approximately 0.62% of the mineral owners. The average weighted fee landowner royalties interest is approximately 16.92%. SM Energy's counsel, Mr. Mayo, prepared the proposed finding of facts, conclusions of law, and order granting the request for agency action. Both the division and I have reviewed and approved the proposed order. It should be now ready for the board review and execution. I'd take any questions if you have them at this time.
Board, any questions?
So, Mr. Rogers, this was a 4-mile lateral, is that correct?
I don't believe it was. I think it was a 4.
This is a section line, boundary line well. So at two 1280s, this is the
okay.
DUBWDSU. We all love
that. Gives me the perspective of the size of the unit then.
That's right.
Thank you.
Yeah.
But the unit was 4 down, yeah, okay.
Yeah, 29 through 32 sections. So, yeah.
I've got another question.
Yeah, go ahead.
It's kind of probably a dumb one, but it's, the first 2 docket items covered the same areas. And so how does, now these 4, can you explain how the...
Maybe it's my turn to do that. We come in for spacings often, and you all listen to us drone on and approve overlapping units of all different sizes in areas. Well, this is the practical application of that. The first matter was a 3-mile unit, 19, 30, and 31. but they'd already permitted and drilled some 2-mile wells in 30 and 31 at the same time. So that was matter 2, I believe, that we've heard here today. And essentially it's a 2-mile unit and a 2-mile unit next to it, and the drilling unit boundary wells that were drilled as part of that development, and then the 3-mile wells that are related. So it's all kind of the overlapping spacing in action is what you're seeing.
Okay. Thank you. Any other questions for Mr. Rogers? Seeing none, division?
Thank you. The division is in concurrence with Mr. Rogers' report. The division's also reviewed the proposed order and has given it approval. Thank you.
Okay. Mr. Mayo, anything else?
Nothing further to add. Thank you.
Okay, Mr. White?
Just similar to the prior matters, this matter should be granted by the board based on Mr. Rogers' recommendations.
Okay, board, any last questions? Okay, any requests for deliberation? Interest there? Hold on, yes, go ahead.
Does this pool one well or multiple wells?
This pools, I've got to remember which one we're on. I don't think there's any individual wells in any of these poolings for SM Energy. I think it's 2 wells, but it could be 3, and I can double check and get you the
That's
exact.
fine. That's fine. Thank you.
But just to clarify, this pooling will apply to all future wells in this drilling unit, correct?
Under the statutes, it will, subject to the board deciding that we've met all the rules and followed all the procedures to secure that. But yes.
Have we done any of those where because it does require you come back and present an updated, like, non-leased or unleased or...
Yeah, so for those of you who have been on the board for 3 or 4 years, there was a wave of poolings that came through a couple of years ago, and there was a bunch of operators, XCL and Ovintiv in particular, that did a series of poolings for a year and a half. A lot of that's the natural cycle. You get all your spacing done and your units set up, you go out and you drill a bunch of wells, and then you got to come back in and kind of clean up the back end with the pooling. The problem is both of those companies sold and exited the basin shortly after that. And so you've got new companies, 4Point and SM Energy, coming in with new priorities, new plans, getting spacing in order. And it's a long way of saying the statute you're referring to, this pooling order shall apply to subsequent wells drilled in the unit, it really doesn't kick in until after wells have been pooled in a unit. So we were kind of just at the point where any additional 2-mile drilling, we probably would have availed ourselves of that statute. Operators have started to shift to 3 and 4-mile units. So until we get 3-mile units pooled and then additional infill wells drilled in those 3-mile units, for example, we probably won't do that. To answer your question directly, I think there's been at least one that the board has approved a motion to modify under that, and I've got several others that will probably be working through the process this year.
So, Mr. Mayo, if we look at the most recent one, or the case that we're looking right now, and then we look at the agenda number 4, which was 132-83, so we've spaced 2 of the sections, 29 and 32, under both of these orders here. So future wells, will they be drilled on the basis of the 4-section unit or the 2-section unit?
That's a really good question, and it kind of is the distinction in spacing between what you see with 4-point orders and a lot of, old Ovintiv orders. There was a lot of conversion talk. I don't know if the board's familiar with that, but essentially, for their 2-mile spacing scheme, once you drilled your first 2-mile horizontal, everything was payable on that 2-mile basis. Absent those specific conversion orders, that's not what happens. And so with the overlapping scheme that SM has on their lands, essentially the board set up multiple different drilling options for them to drill, and to protect correlative rights, you just have to stay away from wells that are drilled in those other units, a distance that the science and experts say is safe to do that. So, I guess it's a really confusing way of saying these sections are included, for example, you pointed to Matter 4. Matter 4 deals with sections 29 and 32 in Township 2 South, 1 West. Those sections are part of a 2-mile unit. They're also part of a 3-mile unit, and they're part of a 4-mile unit because the board has approved those overlapping spacing orders. So that means essentially operator gets out there and has a rig on site that's capable of drilling the full 4 miles, and they've got permits and plans, they'll move ahead. But they've got that optionality kind of built in so they can adjust the drilling and drilling plans based on practical needs, surface availability for well pads and, nearby water disposal wells and stuff like that. And so I don't know if that answers your question necessarily.
Well, not exactly, because we're not talking about a 4-mile well. We're talking about a boundary well that's a 2-mile well.
Yes.
And yet we already have. So a future well, will it be under the 4 sections or under the 2 sections?
That depends where the well is drilled. If the well is drilled in the boundary line corridor that's set up for those DUB, WDSU, then it would be payable on the 4 miles. It would be part of that 4-mile boundary unit development.
So you're talking that this, what we just are looking at right now, applies only to this well. So we're talking 4 sections that are being pooled, but it's only regards to this well and will not be to future wells.
Let me see if I can pull up the exhibits and maybe help answer it so we're looking at something. It'll help us hopefully have an understanding. I apologize for the delay here. I think I'm kind of confused on the question because in number 4, it only deals with sections 29 and 32. In docket number 4, it's docket number 6 that has that involves sections 29, 30, and 31, 32. That's the 4 section.
That's right. So for the purpose of the boundary well, so the order that you have written for this only pertains to the boundary well pooling those 4 sections.
That's right. So the
future wells will be on the 2 well or the 2 mile.
Unless you had a future boundary well, which you could at a different depth. And that future boundary well, this pooling would apply to. Is that right?
That's the way I would understand it.
That's right. I mean, I'm trying to pull up a visual so we can look, but imagine 4 sections of land, 2 1280s next to each other here. You've got, wells drilled in this, clearly in this 1280 are part of that 2-section unit, and we pooled as part of that. Wells that are clearly in this 1280 with no visual representation will be pooled there. If they are in that corridor right along the center line between those two, then as Mr. Moon said, those would need to be permitted as boundary line wells, and they would need to be pooled as boundary line wells.
Okay, that helps. Thank you.
So if you were, going back to item 4, if you were to drill then a 3-mile well, let's say 29 and 32, you were to add a section, would you have to come back and pool that additional land?
Well, the good thing is this is a good test case example because the first docket matter that you heard was exactly that scenario.
Mm-hmm.
It was sections 30 and 31 and also included section 19.
Right.
And so there were 2 separate poolings that were required, one for the wells that produce only from section 30 and 31, and a second pooling order that was required for the wells that produce from sections 30 and 31 and 19. And if a 4th mile is added for subsequent wells and is drilled 18, 19, 30, and 31, a new pooling would be required, new elections, new balloting, and there would have to be sufficient setbacks between those wells to protect correlative rights.
Thank you.
Yep.
Okay. So,
Go ahead, Mr.
ready for a motion?
Well, I'm just going to check, see if there are any other questions or clarifications needed. Any need for deliberation? Oh, wait a minute.
I do have one
Oh, sorry.
question. What was the percentage pooled in this last matter?
I believe it's
0.62%.
Thank you.
Turn your mic on, Mr. Rogers.
Oh, did you get that?
Yes.
0.62.
Thank you.
Okay, now I'll ask. Any need for deliberation? Okay, entertain a motion.
I move that we approve this request for agency action as recommended by the hearing examiner.
I'll second.
Motion's been made and seconded to approve this request for agency action. All those in favor say aye.
Aye.
Any opposed, say nay. Hearing none, it's unanimous.
Mr. Chair, if I can interject before you go to break, the hearing examiner process is something we haven't done for a little while, and we're back doing it. And I want the board to know, I think there's real value there. It's a really good process. I think it does a really good job getting things handled in a way that's efficient. But I do think there's some need for us to kind of all get on the same page as to the process for ease. I didn't submit the orders to Julianne and Patty this morning because I was under the impression the hearing examiner had done that. He was under the impression that I had. And so if we're going to utilize the hearing examiner process a little more, I'm happy to be of assistance if I can, but I think we should, kind of make sure we've got a clear process that works for everyone so we can have it work as efficiently as it needs to.
Okay, I think I'll let you guys work that out. The board won't need to dive into that, but we'll let you guys.
Unless the
sort
board
that out
wants to
amongst
have a
yourselves.
role in setting procedure before the hearing examiner. So something.
I'd rather be flexible and let you guys work it out.
Perfect.
Make your own sausage.
Thank you,
Okay.
Mr. Chair.
All right.
So just a comment, I watched quite a bit of the hearing examiner proceeding, and lots of good questions were asked by the hearing examiners, and I thought it was a good, they had good questions, and I appreciated it.
Yes. Yeah. Well, we'll say it again though, just to make sure. Okay, so just in case I didn't say it, the motion's been made and seconded and is unanimous that the request for agency action is approved. With that, I agree with you on how efficient this is. Here it is a little bit after 10:30, and we've already gotten through items number all the way through 6, and pretty efficient. Let's go ahead. I've got some paperwork. Mr. Rogers and I got paperwork to catch up on. So let's take a break until 10:40 by that clock. We are off the record.
1.
Good morning, everybody, and we're back on the record, and we're going to proceed with agenda number 8, and then we will go back for agenda number 7. So the first item is docket number 2026-10, cause number 600-12. In the matter of the request for agency action of Crescent Uinta LLC for an order 1, establishing stand-up 1,920 acre drilling units. 2, establishing stand-up 2,560 acre drilling units. And 3, amending the board's order in cause number 139-157 regarding increased well density and decreased setbacks, all for the long lateral horizontal well production of oil, gas, and associated hydrocarbons from the lower Green River and Green River Wasatch formations, comprised of A, sections 3, 10, 15 to 17, 19 to 22, 25, 27 to 30, 31 to 34, and 36, Township 1 South, Range 1 West, USM, Duchesne County, Utah, and B, Section 32, Township 1 South, Range 1 East, USM, and Sections 5 to 8, Township 2 South, Range 1 East, USM, Uinta County, Utah. We'll take appearances.
Brent Chicken, Steptoe and Johnson, PLLC, on behalf of applicant Crescent Uinta LLC.
Thank you. Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Thank you. Okay, Mr. Chicken, please proceed.
Thank you, Mr. Chair. As you noted, this RAA requests the establishment of 1920 acre and 2560 acre stand-up DSUs with up to 37 wells per DSU in the subject formations, 185-foot north-south or heel-toe setbacks, 330-foot east-west or boundary line setbacks, and no interwell setbacks. And also amending Order 139-157, which has several existing 1,280 acre spacing units with those same exact specifications, 37 wells, 185-foot heel-toe, 330-foot east-west, and no interwell setback. I do have two matters, preliminary matters that I need to raise with the board. And I have spoken to counsel for the division about these in advance. After the request for agency action, the certificate of service was filed, the hearing notices were sent and published, exhibits published, the response filed, a single transpositional typographical error was found in the RAA. The RAA says 1 south, 2 east for the township for sections 5 and 8, and it should say 2 south, 1 east. There was a question about whether this created an issue with notice, and what I can tell the board is this typo appears in that one place in the RAA. It does not appear in the notice of hearing that was mailed out to all the different parties on the certificate of service. The correct parties were noticed, the owners in sections 5 to 8, Township 2 South, 1 East. After speaking with counsel for the division, who I'd certainly like to give an opportunity to speak here, and providing an example of where this typo existed, it not being in the captions, it not being in the notice of hearing, the card that went out to everyone, and given the fact that Crescent has been in touch with many of the owners who have contacted Crescent asking about the RAA and what it is, and recognizing that some of those folks were already confused and getting another RAA with this one little tiny change would confuse them further, and also recognizing a substantial cost to renotice both for Crescent Uinta and for the division. What we have proposed is we will publish in the 3 newspapers that were that we already published the RAA in. We will publish next week for 5 days in those 3 newspapers a notice of the typographical error and provide folks with anybody that has an issue with that typographical error to come forward and file a response within 30 days. I believe that the counsel for the division is in agreement with this, simply because we're literally talking about probably $60,000 combined to renotice everyone, along with the confusion that will come from that, all to change a typo that does not appear in the caption and does not appear in any of the the relief requested or in the exhibits or any of those items. So that would allow us to go forward today and move forward, and would also allow preparation of a board order within the regular time. And if somebody complains about this typographical error, those rights of those parties would be protected. Personally, I don't think anyone's even going to notice that this typographical error existed. However, we wanted to be transparent with both the counsel for the division and with the board on this. And those 3 papers, by the way, would be the Uinta Basin Standard, the Vernal Express, and the Salt Lake Tribune. And we'll, of course, file, affidavits of publication and proof of publication that actually occurred. And we would do that by, we'd start publishing it by next week for a total of 5 days. I can't promise that we would be publishing right on this coming Monday, but we will publish. We'll begin next week, and it will go for 5 days. Before we go forward, I would like to give the board and the division a chance to ask questions and provide their positions.
Okay, first off, is anything that I just read into the record, is that incorrect?
Nope.
Or is it- Okay, so.
Because that comes from the
where-
caption, and the caption is correct.
Okay, so
So if you
where
look at
was the
page,
error?
if you, the request for agency action on page 2, at the bottom, it says Township 1 South, 2 East, sections 5 to 8.
Yes?
It should say 2 South, 1 East, sections 5 to 8.
Okay. Oh, okay, oh, that's the, okay, so it should say Township 2 South, Range 1 East.
Sections 5 to 8, correct. And that's the sole place where this typo exists. It is not in any of the captions. It is not in the relief requested involving those lands. And I did provide, and I can provide to the board, literally copies of these with the right description highlighted in green and the typo highlighted in pink. But importantly, the actual notice card that the board sends to people is also based only on the caption, and therefore that notice card does not have the typographical error on it.
Okay, and any of the exhibits that you're going to present today, does it have this typo in it?
It does not. It does not. It's in that one spot, and it's also in the division's response, but that's because they copied our list of lands as they should have properly done, and that that typographical error was repeated there. But like I said, the notice of hearing that was mailed and none of the captions have this typo, and on balance, in terms of the confusion and the super high cost of renoticing, we just wanted to, I worked with division counsel to try and find a way that we didn't have to continue and renotice. And based on the actual facts of where that typo appears, we don't believe that anybody's going to have a notice issue as we sit here right now. But regardless, we wanted to go that extra step and say, we will publish notice in the newspaper of this problem in all 3 same papers that the RAA was published in, and let people know there was a typo. And if you have any concerns with that typographical error, or you looked at it and thought you didn't have, that you wouldn't have to be here today or something along those lines, it would protect us on both sides and make sure that everybody understands what's going on. But that's ultimately really the board's choice.
So you're saying the division does not get credit for finding this error?
No, actually, a third-party land professional engaged by Crescent gets the credit for this. I was hopeful that he would have found that before, a week before the hearing, or that I would have noticed that, or any of the folks that touched it. But it is literally such a small transpositional typo that I think everyone literally just missed it.
Okay. Mr. Haynes?
Yeah, we've spoken, myself and Mr. Chicken, on this issue, and I believe the solution that he's proposing is fair. We have had similar things like this happen in the past, and the resolution of having subsequent notice, allowing for an initial period of any kind of response or objection before a final order is issued by the board, does give that extra time. One of the main reasons not as concerned is because the caption that went out for noticing the public and everybody of this was correct. It's only if you actually read in the RAA and you look down in the lands, that one little spot, it was transposed. So I'm in agreement with Mr. Chicken as to the solution to this issue.
Okay. Board, anybody else have an issue with this? Okay, we'll go accept your remedy then.
Okay, and I'll make sure to keep the board's attorney and Mr. Haynes involved in the process, and the record will reflect, and the proposed order at the end will also reflect that we've published that, and we'll make sure that proofs of affidavits of publication from the 3 papers are placed in the record, so that there is a very clear how we handled this, both if somebody were to watch this hearing, or if they look at just the order and the case file, they'll be able to tell what happened here. And I appreciate the board's willingness to save some costs and headache, and another giant round of people calling Crescent asking what's going on. So, okay.
So, Mr. Haynes, we'll leave it up to the division to validate that Mr. Chicken does exactly.
Yeah, we'll review those notices when they come in, and I'm assuming, correct me if I'm wrong, the proposal is that we won't have a final order until this is all put in place.
Correct. I think we could work on that so that we're not too far out of time, but I wouldn't ask for approval of that order until all of this publication has happened and that 30-day period has passed, at which point then the board could sign the order. So hopefully it doesn't screw up board or division timing on that process, but we'll make sure that doesn't happen until we're sure that nobody else cared about that typo.
Okay, so you won't have to publish this order within the next week or 10 days like I'm going to ask everybody else. So good.
No. No.
Okay, thank you. Go ahead and proceed then, Mr. Chicken.
The second housekeeping item here is there was a comment letter filed by a Mr. David Larson regarding the RAA, essentially questioning on a fairly basic level what we were asking for and what the relief requested was. Mr. Larson spoke with personnel at Crescent Uinta regarding the RAA, and then filed a thank you and a withdrawal of his comment letter. And so if there's any questions about that, I'm happy to field that, but I think this was just somebody that had questions, we answered them, and he said, I'm all good. But if there's any questions about that comment letter, I'm happy to answer those.
Yeah, we have Mr. Larson's comment letter in our files.
Okay, thank you very much. So moving forward, the division did file a response in this matter, but that response would support the relief requested today, assuming that Crescent Uinta provides sufficient land, geology, and engineering testimony to support those requests, which we certainly will believe we will do. With me today our three witnesses. For land, we have Roxanne Eveland, who is sitting to my left, a staff landman for Crescent Uinta. We also have Mr. Travis Plemons as the senior geologist, sitting right behind me, and Mr. Mason Whittington as the staff as staff reservoir engineer for Crescent Uinta. And I don't know if we want to swear them all in right now so that they're sworn in.
We'll do that right now.
Yes, would you please stand and raise your right arm to the square? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
Okay, go ahead, proceed.
Thank you, Mr. Chair. The resumes for all three of these witnesses are attached, as you see in this table of contents, R1, R2, and R3. I am not seeking expert qualification for Ms. Evelyn, but I will seek that for Mr. Plemons and Mr. Whittington when their turns come up.
Okay.
And with
Division,
that-
you want to comment on expert witnesses at this time, or?
Yeah, we don't have any objections as to
Okay.
them remaining as experts.
Okay, board, any questions on the experts? Okay, seeing none, proceed.
Okay. So they accept, their testimony is accepted as expert witness testimony for purposes of the hearing?
Yes.
Okay, thank you very much, Board. I appreciate the efficiency there. Okay. We'll move directly into Exhibit L1, which is our general locator map. If you could please describe what you've depicted on Exhibit 1, Ms. Evelyn?
Yes, well,
Oh, actually, I'm sorry. Let me back up. Please state your full name, your employer, and your position with that employer for the record.
of course, Roxanne Eveland, and I am a staff landman with Crescent Energy. And just again wanted to thank the board and the division for your understanding on our typo on our request for agency action. There's a lot of numbers and a lot of townships and sections in there, and we will be double, triple, quadruple checking next time. Lesson learned. So do appreciate that. What you see here on L1, this red outline outlines the sections where we are seeking spacing, increased density, and reduced setbacks. You'll see that it is just north of the town of Roosevelt. And it encompasses 24 sections, which is approximately about 15,360 gross acres.
Okay. We'll move from the regional into a zoomed in, but if you this is Exhibit L2, and so if you could please kind of describe and delineate the area that we are requesting relief in, and also the notice provided regarding this RIA.
Yes. So again, the red outline, anything inside the red outline are sections that are included in our request. Everything that is shaded in yellow and then kind of inside the hashed blue lines on this exhibit, this is where we are required to provide notice to all working interest owners and unleased mineral owners. And just to, make sure we're casting a wide net, we go ahead and notify all working interest and unleased owners in those entire sections. So kind of the green outline there, just everybody inside the green outline has been notified of our request.
Okay, and that means that you have sent a true and complete copy of the request for agency action to all unleased mineral owners and working interest owners inside of the solid green line, correct?
That is correct.
Okay. Moving forward, we'll go to Exhibit L2. If you could describe, please.
Exhibit L3.
Or Exhibit L3, yes, thank you, Mr. Chair. If you could please describe what is on Exhibit L3 in terms of the type of mineral owning parties in the subject lands.
Yes, so here on Exhibit L3, you'll see that the sections that are within our request area are made up of fee, tribal, and state minerals. So the fee is in yellow, the tribal is in green, and the state minerals are in the light blue.
Okay. And so this is probably about, I'd say about 50-50 tribal, state/fee on the other side, correct?
That would be approximately.
Okay.
The,
Moving on to Exhibit L4, which shows kind of what the development is out there right now. If you could please describe what this exhibit is depicting.
Yeah, so this exhibit shows the existing wells, and just specifically within our request area, again, that red area. Of the 24 sections that are within this red area, 17 of those sections already have a Crescent-operated well in them. There are a few sections that have wells operated by others, and there are a few sections that have no current producing wells in them. But yes, but basically 71% of these sections already have a Crescent operated well in them. And then two things I did want to point out is if you look in 2 South 1 East in sections 6 and 7 there, you'll see horizontal wells. Those are Crescent's operated McMullen wells. And then in 1 South 1 West in sections 29 and 32, Crescent currently has submitted for approval for permits for 4 Jensen wells in that DSU.
Excuse me, moving on to Exhibit L5. This is going to give the board an idea of the current existing spacing that is out there on these particular wells.
Yes, so in L5, the blue shade is the existing spacing, which, as you can see here, these are 1280 spacing orders that have previously been approved. Currently, the density under the spacing order, which you can see there, is 139, 157. The current well density is for 12 wells. The inner well setback is 330 feet. The heel toe setbacks are 330 feet, and the section boundary setbacks are 560 feet.
Okay, and so this the blue highlighting here that shows the order 139, 157 lands. That is the genesis of the request today to amend that order to change the well density, inner well, heel toe, and section boundary setbacks for these existing 1280s that are within the red lines, correct?
Yes, that is part of our request today.
Okay. Moving to Exhibit L6, we are now moving into what is actually being requested in terms of spacing establishment today.
Yes, so on Exhibit L6, what you see here are 6 overlapping 1920 acre DSUs that we are requesting. In all 6 of these, Crescent does own over 50% working interest. In addition to asking for these drilling and spacing units, we are asking that the well density be set at 37 wells, that the inner well setbacks, that there are no inner well setbacks, and that the heel toe setback is at 185 feet and the section boundary setback at 330 feet.
Okay. And also part of this request today is the creation of some overlapping 2,560 acre stand-up DSUs. If you could please describe those.
Yeah, so on this exhibit, you will see 4 overlapping 2560s. These will have the same requested density and setbacks as we're requesting for the 1920s and the underlying 1280s. So for consistency's sake, we are asking that they all have the same density and setbacks.
So when we're talking about the subject lands involved in today's request, granting their request would create a situation where the underlying existing 1280s, the newly requested 1920s, and the newly requested 2560s all of which are stand-up, would all then have the same well density and setbacks, correct?
That is correct.
Okay. We'll move on to Exhibit L8, which I think is just a kind of a breakout of those existing 1280s. Is that correct?
Yeah, correct. So again, the existing 1280s, we are just asking that the density and setbacks be revised.
We'll move on to Exhibit L9, which is super busy, but I think we're trying to show everything in the same bucket here, yeah?
That is correct. This is just to illustrate of the request that we're making today, just all on one graphic so that you can see the overlapping nature of the 1920s overlapping the 1280s, the 2560s overlapping both of those. And then you can also see, you'll notice there are two 1280 DSUs, 2 South, 1 East, 6 and 7, and 2536 of 1 South, 1 West, that we're not asking for an overlapping 1920 or 2560 there, but we are asking for consistent well density and setbacks.
Right. And if granted today, all of this relief and these new overlapping units would all be subject to the, now I think I can say standard language in the order that when the board approves wells, it is approving those wells with recognition of a total productive lateral wellbore length, such that it's not 37 wells in the 1280 and then 37 in the 1920, right? It's 37
Correct.
wells worth of productive lateral wellbore across that piece of land, regardless of how the overlapping spacing is.
Yes, that's correct.
Created.
That's correct.
I think this kind of helps show that a little bit. Exhibit L10, if you could please describe what's depicted there.
Yes, for Exhibit L10, just wanted to show for illustrative purposes, this isn't an actual scenario, again, just illustrative, but this would be what the current well density looks like. So with 12 wells, this well density, you'll hear more testimony later in our presentation that suggests that we're not maximizing resource recovery. And so if you want to move to the next one, which is L11.
Sure, this is L11. If you could please continue your discussion and comparison.
Yes, so this would be the comparison showing the requested 37 wells. Again, this is just for illustrative purposes, but it just shows that, this is how we would maximize the resource recovery, minimize waste, and while still protecting correlative rights.
Right, and those correlative rights are in large part protected by just the what we just talked about, which was the total lateral wellbore length and the overlapping but separate nature of the DSUs that we're requesting today.
Correct.
With that, were exhibits L1 through L12 prepared by you or under your supervision, direction, and control?
Yes.
And do you believe that the relief sought today will protect correlative rights, maximize recovery, minimize impacts, and avoid waste?
Yes.
Okay, I have no further questions for Ms. Eveland.
Okay, division?
Yes, could you please go back to Exhibit L9? Yep, there it is. Just so you can get an idea of what's going on in the area, these are all the units you're either requesting to have amended or created. What else is going on in 1 South, 1 West? Do you have the leasehold there? Like the gaps that aren't part of this request today, who owns those, and what's the anticipated development in there if you do own them?
So if you're speaking to, the gaps, you mean like anything that's not shaded?
Yeah.
Isn't included in the request?
Yeah,
I mean,
yeah, right where
right,
the
correct.
cursor is now, and then maybe the northern part of the
Yeah.
stuff that is being.
So, yeah, our request is based on again, as I testified, where we own over 50% working interest. I don't, off the top of my head, know who owns the leasehold and the others, but we would not include a full DSU, so a full 1920 or a full 2560, if we didn't already own 50% of the working interest and be able to be the operator there. I don't believe those are unleased lands. I do believe those are owned by other operators, but not by Crescent.
Okay. And then if we could go to Exhibit L3. This is just touching on ownership. 2 South, 1 East, the areas that we had in question earlier on, 5, 6, 7, 8, those sections. I noticed in those lands there are some state lands and there's also some tribal. Does Crescent have the state leases there or tribal leases there?
So for the state leases, those are leased minerals, but they're not leased by Crescent.
Okay.
They are leased by another party that is executed a joint operating agreement with Crescent for the McMullen wells. And then the tribal lands in 5, 8, and 32, I believe those are also leased to other parties.
Okay, not by Crescent. All right, with that, the division has no further questions. Thank you.
Okay. Board, any questions of this witness?
Yes, could I have you go back to L9, please? So I'm looking at sections 3 and 10 and 1 South, 1 West. And you've got outlines that do not include the whole sections of 3 and 10. There are, is the entire section 3 and 10 to be included or not included?
Yes, it will be the entire section. I think you've just pointed out a limitation in our mapping ability.
Yeah, that's, I was gonna say, it should go to the edges, but
Yes.
if you put it to the edges, then everything's kind of purple. And you can't tell what's what. So yes, it is the full sections. You also have the Duchesne Uinta County line here in that one weird spot. So you actually have some sections that are 3/4 in one county and 1/4 in another, but it is still a 640 acre section, and that is part of the request today.
Okay, thank you.
So, did Crescent drill the McMullen wells then, or?
Yes, those
Yeah.
are those
Okay.
are producing.
Yeah, because this isn't your core operating area. North of Duchesne, you're now north of Roosevelt. Is this a recent acquisition, or you've had these lands for a long time?
No, we've had these lands. I guess I would argue it's all our core position.
Yeah, okay,
but
okay. Fair enough.
Yeah.
Okay. And so the prior spacing request, was that done by Crescent, or was that, who was?
Yes, I believe the underlying 1280s were Crescent.
Crescent, okay.
Yes.
Okay. All right.
Board, any other questions? Okay, go ahead and proceed, Mr. Kitchen.
Thank you, Ms. Eveland. I will now call Mr. Travis Plemons. Mr. Plemons, if you could please state your full name, employer, and title for the record.
I'm Travis Plemons. I'm a senior geologist for Crescent Energy Company.
Okay, thank you. Your expert witness qualification having been previously approved by the board, for your testimony today, I will move directly into Exhibit G1, and if you can please describe what's depicted in the type log and which well it is, kind of where it's located.
Sure. So this is a type well from the requested area. This is the Hurley 233A1, and really just showing that the formations in question are do exist in this portion of the basin, from the top of the Green River to the middle Green River and lower Green River down to the Flagstaff Formation.
Okay, and that is our description of the subject lands, correct? So basically from essentially right here down to right here, correct?
Yes, that's correct.
Okay, thank you. And down here, just to point out, this star is the actual location of that Hurley 233A1 well, correct?
Yes, that's correct.
Okay, thank you. We'll move on to Exhibit G2, which is our geologic cross-section. If you can please also describe what's displayed here, including tying it into the Hurley type log.
Yes, so the Hurley type log is the third well from the left, noted by the blue star on the diagram. So essentially just showing the top of the Garden Gulch down to the Yeatland Butte Formation, and really just depicting the structural, the structure in the area and the requested lands. And really I think the point is that there isn't really structurally a ton going on in this portion of the basin. Really the only thing is the Roosevelt anticline that is to the north, to the northeast of the requested lands. But other than that, it's relatively benign.
Okay, and the cross-section is shown in the pop out over here, correct? All of these wells from A to A prime are all along this line right here, with that type log well being the star again, correct?
Yes, that's correct.
Okay, thank you. Moving on to Exhibit G3, if you could please describe what we're seeing in terms of subsurface structure.
Yeah, so again, just hitting on the same subject here. This is showing us a structural map, a TVD sub-C of the top of the Yeatland Butte Formation, and again, just pointing out the Roosevelt anticline that you can see in the map kind of to the northeast of the requested lands. But again, that is the main structural feature, but we don't anticipate that causing any issues in the development.
Okay, thank you. We'll move to Exhibit G4, which kind of ties in that structure map to should these be stand-ups or lay-downs. If you could please say that more eloquently than me.
Sure. Yeah, sure. So this is showing the maximum stress direction that's really derived from borehole imaging and borehole breakout. And essentially, I think what we're trying to depict here is that these wells should be stand up versus lay down, as the azimuth is east 20 degrees south, which is essentially just saying it's more east-west orientation. Therefore, we believe that these should be stand up wells in the requested lands.
And so the stand-up actually assists in interacting natural fractures as near to perpendicular as possible.
Yes, that's correct.
We'll move to Exhibit G5, which is a potential development example with the requested 37 wells. If you could please describe the Crescent's kind of plan for that type of development.
Yep, so this kind of goes back to the previous land exhibit that we've seen, really just showing this is the 37 wells per section that we're requesting, and this is a example of a potential layout per formation.
Okay. And were exhibits G1 to G5 prepared by you or under your supervision, direction, and control?
Yes.
And do you believe that, based on your testimony, that the request today will protect correlative rights, avoid waste, maximize resource recovery, and minimize impacts?
Yes.
I have no further questions for Mr. Plemons.
Okay. Division?
Division has no questions for Mr. Plemons. Thank you.
Board members?
Yes, Mr. Plemons, I just want to clarify the geologic units that you're spacing here. In the description under the docket 612, you say Lower Green River and Green River through Wasatch formations. Green River through Wasatch, that to me says you're including all of the Green River and all of the Wasatch, and yet you've broken out the Lower Green River. So I'm trying to decide, what does that mean, Green River dash Wasatch?
Sure. So what we were, I guess, trying to describe is essentially from the top of the Garden Gulch Formation, which is the Lower Green River, to the base of the Wasatch, which is what we're considering the Wasatch Formation. So really, we're trying to encompass the top of the Garden Gulch down to the base of the Wasatch Formation, which would be the top of the Flagstaff.
Okay, so that's confusing to me that you've broken out Lower Green River and then Green River through Wasatch. That to me, it says you're including all of the Green River.
And sure, and maybe that's more of we maybe could have worded that a little better.
Okay, so it clarifies to me that.
Yes, sir. Yep. Yeah, so but essentially that's what we're asking for in this is from
Okay.
Lower Green River to base of Wasatch.
Lower
so I
Green River,
apologize.
base of Wasatch.
Yes, sir.
All right, thank you.
You good, Mr. Church? Okay. Any other, go ahead.
So in G5, it's encouraging to see 7 wells proposed or on this exhibit in the Uteland Butte. And you're able to do that because the Uteland Butte's thick enough there, or there's multiple zones in the Uteland Butte? Just explain what's going on there, because a lot of times we just see 4 wells in the Uteland Butte, and then we've got to go somewhere else. And so, anyway, explain it.
Sure, and again, this is an example of a potential development, and I think we would need to go in, the technical team go in and clarify, okay, what exact benches within the Uteland Butte could be a potential target and what can't. I think a lot of that work still needs to be done and worked through, but to drive the point home, essentially, we're saying that the 37 wells per section here we're accurately draining the requested area.
Okay. So in other areas, have you done more than 4 wells in the Uteland Butte and made that work?
I believe in other areas of Crescent's position that has been attempted. So it's been done before in other parts of the basin by Crescent. And again, I would think that in this portion of the basin, more technical work needs to be done to see if that's doable.
Anything else, board? Okay, go ahead and proceed, Mr. Chicken.
I would like to call Mason Whittington as our next witness. If you could please state your full name, employer, and title for purposes of the record, please.
I'm Mason Whittington. I'm a staff reservoir engineer with Crescent Energy.
Okay. I will move forward directly into your exhibits. We'll go with Exhibit 1 first here. And I think this is kind of a little bit of a description of where the basin is heading generally.
That is correct.
So if you could describe what your research has led to that issue, please.
Absolutely. So as he alluded to, this is just highlighting the basin's activity in the recent years. So the top left bar chart you see there, that is depicting the approved permits for horizontal wells over 9,000 feet, where your green bars represent laterals of roughly 9,000 feet to roughly 13,000 feet. The yellow bars represent laterals of roughly 13,000 feet to roughly 17,000 feet, and your red bars represent laterals of roughly 70,000 feet to roughly 21,000 feet. Depicted in that bar chart, you can see that as of 2020, there's been a rapid increase in basin activity. And then as part of that increase in activity, operators started to approve and drill longer laterals of the 3 and 4 mile variety. And those, as of 2023, that percentage of longer laterals has continued to increase as depicted in the top right bar chart, which again, this represents the approved permits, but on a percentage basis. And from 2023 through 2025, there's been an increase in momentum of those 3 and 4 mile laterals, whereas of 2025, about 30% of the approved permits are 3 or 4 mile laterals.
Okay, and then that locator map, the green and the yellow match up with the green and the yellow above in terms of basically the 2 mile wells versus the 3 and the 4s in yellow.
That is correct.
Okay. We'll move to Exhibit E2, which kind of discusses our request to reduce the heel toe setbacks and the boundary setbacks in the existing 1280s and to establish those same setbacks for the requested 1920s and 2560s?
That is correct. So this is meant to be an illustrative purpose and to reiterate the setback requests that we are requesting today, the changes there. And again, the heel to toe side requesting from 330 existing down to 185 feet, and then to a DSU boundary requesting a change from 560 feet down to 330 feet.
And so this change is going to increase productive lateral length, but yet still protect correlative rights, correct?
That is correct.
Okay. We'll move on to Exhibit E3. If you could please describe what is depicted here.
Absolutely. So these are some vertical wells that have had offset horizontal operations and development within their respective DSUs. These are some vertical wells that we have showcased in a previous exhibit, and the exhibit number and the docket number are listed on the bottom left-hand side of this slide. This does showcase and support the interval setback we're requesting today. The first black line on the left of these 4 vertical wells that corresponds to the first round of horizontal development in this particular DSU, and these 4 vertical wells showcase the typical response that we see in our vertical wells by horizontal fracturing operations, of where that vertical wells see a positive or a neutral impact to their performance. There is no detriment to the performance. One thing I would like to note about the first round of horizontal development of this DSU, that was with the interwell setbacks of 330 feet. After about a year later, we came back and did additional development of horizontals in this DSU at the reduced setbacks that were granted based on that exhibit and docket number listed below. The reduced setbacks were 100 feet this time. And again, these vertical wells show the typical response that we see on our acreage positions of a positive to a neutral impact on vertical well performance. So the decrease in interwell setbacks in this particular example did not cause any detriment to our vertical wells and their performance, and we believe what we're requesting today will also not cause any detriment to vertical well performance. One thing I would like to note is these are on our western acre position, where, as it has been noted today, that a lot of our historical development has taken place. However, we do believe this is going to be representative of behavior we see across our entire acreage position, including the north and eastern portions of our acreage that is of discussion today.
Okay. We'll move on to Exhibit E4. If you could please describe how this works into the setback requests.
Absolutely. So this is the drainage, the Hale and Evers drainage model, which I know is the preferred model to be using. And this ties back into our DSU boundary setbacks as well as the heel-to-toe setbacks. So when we apply Crescent Energy's internal petrophysical and PVT data into this model, we get the drainage profiles depicted in the table on the bottom right, as well as the graphic shown below. One thing to note is all these drainage profiles are calculated at the 110 azimuth that lines up with the maximum horizontal stress as previously discussed. Based on the results of these various production drainage profiles, we expect the heel-toe drainage impact to hit a DSU boundary no sooner than 10 years. And beyond 10 years over the life of well, we expect there to be negligible drainage and offset DSUs.
Okay. I believe this is your last exhibit, E5. If you could please describe the economics of the proposed wells as these laterals get longer.
Yes, absolutely. So there is a significant improvement in economics by being able to drill 3 and 4 mile laterals or 15 or 20,000 foot laterals. This table on the left side in blue does represent the summary economics of the 2, 3, and 4 mile laterals, showcasing the estimated ultimate oil recovery, total severance tax, as well as the total royalty revenue for each of those respective lateral lengths. On the right side of the table in green does show the incremental value of being able to drill a 15 or a 20,000 foot lateral, with the base case being your 10,000 foot lateral. Being able to drill longer laterals does provide a lot of capital efficiencies. It's a more cost efficient method of development. It allows us to put more wells on a particular pad, and also gives us a significant amount of flexibility to tie into existing infrastructure, thereby minimizing surface impacts.
So based on this chart, as between the 15,000 foot or 3 mile and 20,000 foot 4 mile, the incremental looks like you're roughly doubling the economics by adding that extra mile to a 3 miler.
That is correct.
Okay. Where exhibits E1 to E5 prepared by you are under your supervision, direction, and control?
Yes, that is correct.
And do you believe that the relief requested today will protect correlative rights, avoid waste, maximize resource recovery, and minimize impact?
Yes, that is correct.
I have no further questions for Mr. Whittington.
Division.
Yeah, just a couple questions. If we go back to E3, so the request today is for no interwell setbacks. When you perform operations and there is a vertical or directional well in the area, could you just explain what protections are taken to avoid any issues with existing wells?
Absolutely. So there's a variety of workflows we work through in order to basically protect any vertical wells and the remaining value on said vertical wells. Sometimes we just can shut the wells in and monitor, and if we think it's not be very much of an impact to the vertical wells. If it's a little bit closer, we think there could be potential for impacts. We do take additional measures. We might set a plug or something like that to make sure we're protecting surface use as well as the remaining value of those vertical wells.
Okay.
That's something we continually monitor.
Okay. And in this exhibit, we're looking at, I presume it's presented to show there's no detrimental effect to existing wells. Are you aware in your other operations, have you seen times where there has been detrimental effect?
I'm not aware of any in the Uinta Basin.
All right. Thank you. Can we also go to Exhibit E5? And this is just a question related to economics. You have a summary here of economics. It makes sense as the wellbore length doubles, you get double the oil. But what about costs? What's the difference in cost between a 10,000 foot and a 20,000 foot lateral?
So we say on the cost side of things, it is more capital efficient. There is a cost reduction of about 10 to 15% when you go from 10,000 feet to 20,000 feet.
Okay, so about 10 to 15%
Yes,
savings.
that is correct.
Okay. All right, thank you. No further questions.
Okay. Thank you. Board, do you have questions of Mr. Whittington?
I'll
Go ahead.
on setbacks, the 185, we see a lot of 100-foot setbacks, but looking at your exhibit, it doesn't look like you have room. You have 40 extra feet there. Just in general, why do you think your area here needs the 185, whereas a lot of other areas, maybe you are 185 up north of Duchesne, I think you might be, but a lot of others are at 100. Are they? Yeah. Anyway, just give me your thoughts on that, because that really is, permanently not abandoned. What's the word for it? You can't.
Yeah.
Strandings. Yeah, it's permanently stranded because you're not going to get it's hard to get to that ever again. So, and just your thoughts on that.
That's a very keen observation. I would gladly take 100-foot setbacks if you want to grant me that. But based on the data we have, the internal analysis that we have, the data I have running through this model, I can support confidently with 185-foot setbacks. If I get additional data that says, no, those need to go down to 100-foot, then we will definitely come back and request that new setback change. But right now, I can't support that with the information I have in-house to date.
Okay, good. Yeah, do come back if the first well shows something different. However you figure that out.
I'll be on the first slide out.
Come back in.
I'd just like to point out too that diagram he has that's for 5-year drainage. I assume the issue is as you get longer out, it becomes a lot closer.
Correct. That envelope does continue to expand.
Yeah. So what is in the brown right there? That's 5 years?
That's the 5-year drainage radius, yes.
Is that consistent with what other operators are
it varies. Some will show us 10, some will show us 5.
But they're not showing 1 in order to get 100 foot.
Nobody's doing 1, yeah.
Okay.
And for reference, the table on the right does show out to 10 years. The graphic just says 5 years. So the 10 years is when that range radius would get to about the 185.
So in other words, at 10 years, that brown is not 237 feet anymore. It's 270 almost.
Correct.
Getting close then.
Or at least too close for comfort until we actually drill one.
Yeah, especially where a lot of this is bumping up against other operators too, so be careful. So. Okay.
Yeah, we don't want to have that stuff stranded, so take a hard look at that when you have more data.
Absolutely.
We'll be receptive to listening to you.
Thank you.
Yeah, especially where, if your neighbor's doing 100, as well would be doing 100 too. I mean, I'm not telling you to fudge the numbers, but there's just a give and take there, and an overabundance of caution can strand oil. And so, yeah.
Okay, board, other questions? Okay. Division?
I have nothing additional for this witness.
Okay. Mr. Chicken, go ahead.
First, I would like to ask the board to please admit exhibits L1 to L12, G1 to G5, and E1 to E5 to the record.
And R1 also?
Yes, R1, R2, and R3, which are the resume exhibits. Thank you for the reminder, Mr. Chair.
Thank you. So admitted?
Based on today's testimony, subject to the additional notice that we will be giving due to the typo we discussed previously, Crescent Uena requests that its RAA be approved today to establish the sought 1920 and 2560 stand-up DSUs with 37 wells, 185-foot north-south, 330-foot east-west, and no interwell setbacks, as well as amending Order 139-157 for the same exact well density and setbacks for the existing 1280s. And I have nothing further unless the board or division have other questions.
Okay. Board, any additional questions? Or how about deliberation? What do you feel here? Oh, I'm sorry. I'm sorry.
We're happy.
Go ahead.
We're happy to make a statement. Yeah. Based on the testimony that we heard today and the previous evaluation of the exhibits in the RAA, the division does not object to the granting of the creation of these drilling and spacing units and the amending of the order. Thank you.
Okay, thank you. Okay, so now board, any further questions or what's the thought on deliberation?
We're good.
We look like we're good? Okay. With the caution that we don't want to have any stranded oil out there, so take a hard look later on. Okay, with that, I'll entertain a motion.
So I would move that we approve this request for agency action.
Second? Second. The motion's been made and seconded that we approve this request for agency action. All those in favor say aye.
Aye.
Any opposed? Say nay. Hearing none, it's unanimous, and please prepare, who's going to prepare the order here?
I will prepare the order.
Okay, Mr.
Chair,
Chicken.
thank you.
Prepare the order. Okay, so let's just ask here, how fast can you do number 7, or should we take a break for lunch at this point in time?
25 minutes.
Let's
It's,
proceed then?
it's even more vanilla than this.
Okay. Let's go ahead and proceed with agenda number 7 then, and then we'll take our lunch break after that.
Thank you.
Okay. Yeah, when he sits back down again. Okay, so that went through 42. So that one took almost an hour, but we had a lot of hemming and hawing about the, yeah.
In 1 second, I will have this up.
Okay. Okay. And just a reminder to everybody, we've taken these out of order. We're going back to agenda item number 7, which is Wasatch Energy Management.
I'm ready to proceed when
Okay.
Chair.
Let's take appearance for record. Oh, I'm sorry.
That's the most important part, the caption reading,
Sorry.
right?
Let me do that then. Okay, so we're talking now about agenda number 7, docket number 2026-001, cause number 130-45, in the matter of the request for agency action of WEM Operating LLC for an order, 1, establishing certain laydown 1920-acre overlapping drilling units, 2, establishing certain laydown 2,560-acre overlapping drilling units, 3, establishing certain laydown 3,840-acre overlapping section line drilling units, and 4, establishing certain laydown 5,120-acre overlapping section line drilling units as to long lateral horizontal well production of oil, gas, and associated hydrocarbons from the lower Green River and Green River Wasatch formations of sections 29 to 32, Township 4 South, Range 3 West, USM, and B, Sections 5 to 8, 25 to 29, 32 to 36 of Township 4 South, Range 4 West, USM, and C, Section 1 to 2, and 11 to 12, Township 4 South, Range 5 West, USM, all in Duchesne County, Utah. Now let's take appearance for the
Thank you.
record.
Mr. Chair, Brent Chicken, Steptoe and Johnson PLLC, on behalf of petitioner WAM Operating LLC.
Okay. Division?
Assistant Attorney General Nico Micheletti on behalf of the Division of Oil, Gas, and Mining.
Thank you. Go ahead, Mr. Chicken.
Today's request was originally filed and noticed for the January 2026 hearing. After speaking, folks from WEM spoke with technical folks from the division. There was a spot where there was an existing stand-up and a requested lay-down that were going to overlap. Rather than getting into the technical and or legal issues with that, the decision was made to simply seek leave of the board to amend to remove that overlapping new spacing unit to avoid that problem. And to remove that request, the leave was granted, the amended application was filed, and because we were removing lands, we also did not need to renotice that after discussing with Division Counsel. The amended RAA requests the establishment of, as noted by the chair, various laydown 1920 and 2560 3 and 4 mile DSU or spacing units for horizontal wells, along with companion 3,840 and 5,120 section line DSUs. But across the board, all of those DSUs, the standard DSUs request 16 wells, 100-foot east-west or heel-toe setbacks, 330-foot north-south or boundary line setbacks, and 100-foot inner well setbacks. The section line DSUs, their setback is, of course, not drawn inward from the outside, but from that section line and how far out you can go from that. And of course, those section line DSUs are up to 3 wells, not 16. I don't think you could fit all 16 like that, but and in large part, a lot of the reason, not only because the basin is going more towards these longer, more effective and more economic wells, but also you'll notice that, as you'll see in some of our exhibits here, a lot of these lands are right up there in the city of Duchesne, and this helps us move those surface facilities away from the city so it's not getting close to people's backyards and properties and things like that. We can drill from pretty far away. With me today are WEM's land manager, Alex Nielsen, right next to me. Our Stephen Phillips is the VP of Geoscience for WEM, and Dustin Trike is the Chief Operating Officer and Engineer at WEM. As you can see here, their resumes are attached as exhibits A, B, and C. I would ask that all 3 of these individuals be sworn in, please.
Let's check with division. Any issues with these experts?
No issues.
Okay, board, any issues? Okay, go ahead. Mr.
Please stand and raise your right hand. Do you swear, do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
And just to confirm, the board is accepting Mr. Trike and Mr. Phillips' testimony today as experts in petroleum engineering and petroleum geology, respectively, correct?
Yes, we've accepted them in the past.
Before I move into the first exhibit and first witness, I will note that there were no public comments or other responses filed here other than the division's response. The division's response indicated that, once again, provided there was sufficient land geology and engineering testimony and evidence provided at the hearing today that the division does not oppose the relief sought here. With that being the case, I will call my first witness, Mr. Alex Nielsen. If you could please state your full name, your employer, and your title with that employer for the record.
Yes, my name is Alex J. Nielsen. My employer is Wasatch Energy Management, LLC, and my title is a land manager.
Okay, thank you. We'll move directly into amended Exhibit D, which is the kind of an all-in-one exhibit that shows sort of the location of these lands, the notification boundary and the ownership. And if you could please describe what you've depicted on Exhibit D.
Yes, the first thing I would note is the larger notice area here is the surrounding red outline that we're looking at here. So this is in Duchesne County in the 4 South, 4 West, 4 South, 3 West, 4 South, 5 West. Those are our core areas, but also we went up both north and south of that for the notice area. As for the blue outline there, that shows a previously spaced area that we've been talking about with the board for some time here. And we've got our subject lands in the black outline there. So that's both up north there and down south there, as Brent was describing earlier. And then finally, we've got our different ownership types listed out here: tribal, state, and fee that we've identified.
Okay, and just to clarify, so the subject lands today are in the black dotted outline, so we are, the request today would affect lands inside of that, the larger solid blue line, the cause 130, 138, which I'm sure the board will remember was our, WM did that order to basically make uniform in here, and so you're just continuing with that process with the request today?
Yes, that's correct.
Okay. And you did provide notice and copies of the RAA to all parties, working interest and unleased mineral owners that own within the red outlined notice area, correct?
Yes.
Okay, thank you. We'll move on to Exhibit E. If you could please, I alluded to this earlier, but if you could please describe what we're depicting here.
Yeah, so you'll see that this is in the upper, the 4 South, 5 West, Section 1 and 2, as well as the 4 South, 4 West, Sections 5 and 6. And right there is Duchesne City. This new, larger DSU is designed both, economically to make sense for us, but also to not disturb directly in the city areas. There, so with we're proposing a DSU for 4 mile potentials there with pad locations, a good distance away from the city and the citizens of the city.
Okay, and so that, and that's, at least for this 4 mile laydown 2560, that pad location is going to, this is one of those examples, and this is why we're trying to be a little further away with the surface from Duchesne, but we're going to be able to develop all the way over to the, through Section 2, correct?
Correct.
Okay. We will move on to Exhibit F. If you could please describe what is depicted here.
Yeah, so this is just a look at that initial spacing that we had here. You'll see it's a lot more 2 mile 1280 DSUs and just a few 3 mile 1920 DSUs in the bottom left corner of that area. So this is just some previous spacing for our position.
Right, and this kind of shows that the outline for the 130-38 order as well, correct?
Yes.
Okay. So if we move to Exhibit G, what is depicted there?
This is some continued spacing that we've had approved by the board before, so some overlaying overlapping DSUs, 1920s, and if you compare that to the previous slide, those were 2 miles there, and now we're looking at 3 mile 1920 setups there.
Okay, and then these are also some of your, Exhibit H is showing some of your section lines, is that correct?
That is correct.
So these are the 2560s that exist right now under 130-38, correct?
That's right.
Okay. And then if we move into Exhibit I, these are also showing, is this showing additional 2560s under 130-38?
Yes.
Okay. Now we'll move into the 3 mile section line wells, correct?
That's correct.
So these are all the 3840s existing under 130-38.
Exactly.
Okay. We'll move to Exhibit K, which is also showing the same thing, 3840s.
Yes.
Okay, and again, under 130-38.
That's right.
So, and by the way, there's multiple exhibits here, I believe, because if you were to try and stick these all on one, it becomes super confusing.
Yeah, yes, this is
Okay.
meant to be more visually comprehensible.
Okay.
Even though it takes a lot of slides, yeah.
Yep, that's kind of what I thought. We'll move to Exhibit L. And so this is what the request today is in part seeking. Can you describe what's depicted here?
Yeah, so this is the 4 mile DSUs that we're talking about, the 2560. So we've already looked at in a previous slide that most northern one right there, right around the Duchesne City, but then also there are 3 other 2560s, as well as the 5120s overlaying those same lands.
Right, and so the previous slide, Duchesne City's right in here about where my cursor is circling, correct?
Yes.
Okay. Moving on to Exhibit M, these are also your new requests. If you could describe how those fit into this.
Yep. So also overlaying is these 1920 acre DSU requests in the southeastern portion of this lands here, as well as 3840s over the tops of those.
Okay, and so all of these being, both the existing and the ones that are being requested today are be overlapping in nature. And so, well density is impacted by the standard, now standard language in board orders for horizontal development of the total lateral footage, correct?
That's correct.
Okay. Let's see, I'm gonna back up. Were exhibits D through M prepared by you or under supervision, direction, and control?
Yes.
And do you believe that the relief sought today in terms of the new 1920, 2560 laydowns and 3840 and 5120 section line DSUs will protect correlative rights, prevent waste, maximize recovery, and minimize impacts?
Yes.
I have no further questions for Mr. Nielsen.
Okay, Division?
Division has no questions.
Okay. Board, do we have any questions? Appreciate the extra graphics. That helps.
They get bit.
Yeah.
They get
Even though
busy.
it's more exhibits, it still makes it clearer.
Thank you, Mr. Chair.
Okay. No questions from the board? Okay. Go ahead and proceed, Mr. Chick.
I'd like to call my next witness, Mr. Stephen Phillips. If you could please state your full name, employer, and title for the record, please.
Yeah, Stephen Phillips. I work for Wasatch Energy Management, WEM for short. What was the other one? Oh, title, Vice President of Geoscience.
Move right into Exhibit N. If you could please describe the type log and the formations that we're targeting with the additional DSUs being requested today.
Sure, yeah. Absolutely no change from any of the current spacing. We're really just looking at longer laterals here. So what you're looking at here is a map of the basin. It's a little dated, but it shows with the little star there, the type well that is shown on the right, which is the Brotherson 111B4. It's one that we've used in the past, and many operators have used as well. I did notice, Mr. Church, the language there is very similar to the previous hearing, and so we are just asking for the lower Green River through the base of the Wasatch and top of the Mesa Verde. For our spacing interval, and that's what's being shown there on the type log. You can also see the subject lands there highlighted in blue.
Okay. We'll move on to Exhibit O, which is going to, if you could please describe what is depicted here and how that affects well orientation.
Yeah, absolutely. We're not going to change orientation, so we're just extending lateral lengths. I just wanted to show you here that on the west side of the basin where we are located in this subject area, that all of our wells are going to be in the laydown orientation so that we can be perpendicular to SH max.
Okay. And going to Exhibit P, which speaks to our, or at least partially speaks to the setbacks being requested. If you could please describe how that fits into the 100-foot east-west, 330-foot north-south, 100-foot inner well.
Yeah, this would be for Mr. Treg.
Oh, okay. I thought there was this and then one for him. Okay.
No, sir.
Well, if that's the case, then I will ask if exhibits N through O were prepared by you or under your supervision, direction, and control.
Yes, sir.
And do you believe that the relief sought today will protect correlative rights, prevent waste, maximize recovery, and minimize impacts?
I do.
Okay, I have no further questions.
Division?
No questions from the division.
Okay, thank you. Board, any questions from board members? Go ahead.
Yeah, so just your thoughts on 4 mile laterals. Have you, I believe SM has drilled some.
They have.
Have you drilled any yet, or?
You know, we are long lateral leaders. I think we drilled some of the first long laterals in the basin in the Greater Monument Butte unit. We love them. And really, I love your question because this isn't really, the spacing here is not a change driven by geoscience. It's a change driven by economics and technology, the ability to drill longer laterals. You're going to see some slides from Mr. Trike that show the economic benefit of those 4 mile laterals. We think they're fantastic. We do think that as you get further south in the basin and you're shallower, they're going to be harder and harder to drill. And the reason for that is you don't have the same weight in the vertical portion of the wellbore. So we're kind of preparing for that, and we're going to kind of watch as we march southward, see if we can, you know, if we reach any kind of technical limit for that. But under the town of Duchesne, it should work fantastically. It's fantastic because we get outside of the city and out of the view shed and just out of people's hair.
Mm-hmm.
So, but yeah, good question.
Thank you.
Mm-hmm.
Okay. Go ahead then, Mr. Chicken.
I
Phillips.
would like to call Mr. Trike. If you could please state your full name, employer, and title for the record, please.
Yeah. I'm Dustin Trike. I'm the COO at Wasatch Energy Management, also known as WEM.
Okay. We will move first to Exhibit P. If you could please describe what's depicted here and how that impacts the requested setbacks.
Yes, so this is our setback diagram. We have no changes from previous spacing hearings. So we're showing here is that wellbore running east-west across the screen, and then the black line represents the section lines. So we're requesting the 100-foot heel-toe setbacks and the 330-foot lateral setbacks from section lines. And then we're also illustrating our estimated hydraulic fracture ellipse, like our drainage window, with a 252-foot fracture half length. So you can see at 5 years, we don't encroach on the section lines. And fortunately, in this case, we have the 0-degree SH max, so we're perfectly vertical in this case for the fracture ellipse.
Okay, we'll move to Exhibit Q, which also informs setbacks. If you could describe what's depicted.
Yep, so this is the same drainage model we've used previously, using Hale and Evers reservoir modeling with the parameters from the previous slide, like the 252-foot fracture half length, and our reservoir parameters. You know, at year 5, we show maximum drainage just below 100 feet, and then at year 10, we have very minimal impacts to adjacent lands. At year 10 for these horizontal wells, they are in stripper status at that point. They're very low volume. So we're doing our best to leave no oil behind.
Okay. We'll move to Exhibit R. If you could describe what we're showing here in terms of economics.
Yep, so our economics slide, I think I'm gonna start in the top right. That chart is a cumulative oil chart comparing 2 sets of wells. This is our goat pad. The green wells are the average of the 3-mile wells, and the red is the average of the 2-mile wells. So you can see here, very easy to see uplift. When you drill that 3rd mile, we are seeing a linear recovery. We are capturing more oil out of the same wellhead versus a 2-mile well. And the chart below that just illustrates, you know, when we can dilute the fixed cost of drilling a well across a longer lateral, your dollar per barrel for the F&D costs, like the finding and development costs, is dropping. So the economics in this case, we're capturing more oil at a lower capital per foot. I believe that the basin is moving in this direction. Mr. Moon, to your question on the 4-mile laterals, SM is drilling them. They've been successful. We've been really successful with our 3-mile wells to date, and we have no reason to believe that the 4-milers won't work. So at this point, it's just a race to who's going to drill the longest, fastest laterals. I believe that it's going to continue to get longer. There's already folks piloting 5-mile laterals in other basins, so it's coming. And in this case, you know, when you're operating around the town of Duchesne or Roosevelt, the longer laterals are super effective to avoid, you know, densely populous areas.
Okay. Oops. Were exhibits P through R prepared by you or under your supervision, direction, and control?
Yes, sir.
And do you believe the relief sought in this RAA will protect correlative rights, avoid waste, maximize resource recovery, and minimize impacts?
Yes, sir.
I have no further questions for this witness.
Okay, thank you. Division, any questions?
Yes, a couple questions for this witness. First question, could we go back to Exhibit Q, please? Perfect, yes. Could you elaborate a little bit more what very minimal impacts to adjacent lands at year 10?
Yeah, so if you look at the table in the bottom right, I think this is the best way to visualize it. At 10 years, your AF, in this case, is 281 feet, and your BF is 124 feet. So with that 100-foot heel-toe setback, yes, at year 10, you technically have drained 20 feet over the section line. But in this case, when we look 10 years out on a typical forecast from a value standpoint and volume standpoint, you're going to produce, I think it's like 80+% of the volume in the first 3 to 4 years. So the horizontal wells just decline so quickly. The drainage, the impact you're seeing at year 10 is very small from a volume standpoint.
Now I'm gonna let our division experts ask a question. I couldn't really hear exactly the question, so.
Megan Crocker with the division. I just had a question on flaring. Since we've had flaring in the past, just want to make sure there's enough takeaway for all of the new drilling that you have. And are you going to be doing any more or adding any more pipeline capacity, or what's the status on that?
Yeah, we're actually in really good shape from a flaring standpoint. We're actually not flaring right now. Credit to our neighbors, 4 Point, Berry, and Scout, now California Resources. We're able to accommodate us as we're getting the compressor station up and running. So we'll continue to build out our infrastructure. I don't foresee this being an issue from a flaring standpoint. We've got our pipeline that connects all of our acreage into the ground, and we have our tap into Williams complete, and the final step is finishing the compressor station. So really appreciate the patience that the board and the division had with WEM as we were grappling with that issue. But we fortunately put that one in the rearview mirror completely.
No more questions from the division.
Okay. Let me ask one question. Did I hear you mention CRC, or is this a different California Resources?
Yes, sir, CRC.
What's their role out there?
They acquired Berry Petroleum. So they are our new neighbors to the south. We really haven't had a ton of time to interface with those folks yet, but they're getting their hands around the asset, and they're excited to have them in the basin.
Okay, cool. Okay, thank you. Board members, go ahead, please.
Yes, Mr. Trate, could we go back to Exhibit R, please? So I'm interested in the performance curve. Is that a specific well that you're showing us there, a historical, or those are projections?
This is actual production data. So those
from a
two
specific well.
Yeah, these are so the green line is an average of 2 3-milers, and the red line is an average of 2 2-milers. It's a 4-well pad. You've got 2 3-milers heading in one direction and 2 2-milers heading in the other direction. So they're like rock, same formation, same frac, very analogous from all of those variables. And what we're really just trying to illustrate here is that when you're drilling that 3rd mile, you are definitely recovering additional barrels. And this chart's only 300 days. So we're seeing that uplift within the first year. For a long time, there's a lot of hesitancy to drill the extra mile because there was this idea that you weren't actually recovering barrels in the 3rd mile. Our data points the other direction, and I think that everyone in the basin and in the lower 48 at this point would agree that the 3rd and 4th mile are super effective, and we're seeing contribution from those miles in the first year.
So this is right in the area.
Yeah, this is our goat pad. We talked a lot about this during our flaring days. This is right on the southern side of our acreage, but very analogous to the rest as you move north. And these are all Uteland Butte horizontals. That's our tier 1 most drilled target at this point. So we would be piloting our 4-mile tests in the Uteland Butte horizon. I imagine we show you this chart again in a year with the 4-mile wells with a stair step above the 3-mile wells.
Thank you. It's very impressive. Yeah.
Thanks.
Other questions by the board? Good. Mr. Moon?
So, but there is a recovery factor that's quite low. That's just standard in general. It's like 5 to 10%.
Yes.
Just talk about that for a minute. Are we improving that at all in general? Is that other 90% going to be recovered someday?
I would say one common theme in the industry right now is folks are moving towards their different proppant styles and better surfactants. I will never underestimate the technology, because it's funny, like it wasn't that long ago that drilling a 3-mile well was this really complex taboo thing, and now it's not. I think the laterals will get longer and recoveries will ultimately get better because of technology, but those are things that we'd like to pilot this year. But there is quite a bit of talk in the industry right now on surfactants and different proppants that are going to increase recoveries. But you're right that these horizontal wells, from a percent recovered, they are relatively low. But never say never. Technology is going to find a way to get more oil out of the ground.
Is that mostly just further out from the well bore? You're much like right next to the well bore. Are you getting 50, 60, 70% of it? And then as you get out, it's much less? Or is it just that is there another reason?
That is a great question. And I believe that's probably correct. Like closer to the well bore, you have better, we have a more complex fracture network. The stimulated rock volume probably it has more permeability there. And as you get further away from the well bore, you're getting into less permeable rock because it hasn't been stimulated by that frac as effectively. So that's definitely part of the equation. But yeah, it's a hard question. It's hard to grasp how many years it's going to take to really make an effective leap on recovered percentages.
Yeah, what made me think of it is we're worried about getting this exact setback, 100 feet, 100 and whatever feet, but we're only getting 5 to 10% anyway. So any extra drainage out there 10 years is just a small, lower, recovery factor. Plus, it's out there 10 years, so we're not recovering much oil anyway. So
absolutely.
So
agreed.
It's good to get close to those setbacks.
Do these wells produce any measurable water?
They do. Just as I would say, like round numbers across the basin. A typical Utland Butte is probably 40 to 60% oil cut. So, for every barrel of oil we're producing a barrel of water.
Okay.
And that's the water that, in our system that we recycle and use for frac. And a lot of operators are going that direction too. But yeah, I would say 1-to-1 is a very normal. In some horizons, it's 2-to-1.
Thank you.
Oil to water.
Thank you.
Yeah, I could ask questions all day. But what percent of how much fresh water versus recycled water are you using on your fracs?
In 2025, I think we got it down to we were a majority produced water, and it's one of those things that's tied so close to our infrastructure capabilities. So early in 25, when we didn't have the produced water storage, we were leaning heavily on fresh, and then by the end of the year, we were fully produced. I can tell you, we just sold some water to Scout on a recent pad that they were, I want to say it was 90+% produced water. So yeah, it's been a tremendous savings for us, trying to minimize our reliance on fresh barrels. They're more expensive and they've got better places to be than used for frac.
And the produced water works just as well as fresh water.
It does. We haven't noticed a performance impact yet. Granted, there are additional things that you need to do, like our produced water has to go through a processing system and then sit in ponds for storage before we can send it to frac. So there's more nuance to it, but at this point, we're going to continue to push that direction because we believe that it's the juice is worth the squeeze at this point.
Good. Yeah, because I watched Scout put in a flat line clear from the Green River.
Mm-hmm.
And pumped, and then they started rolling it up, and they're still fracking. Is that because they're getting water from, through your system?
Yes.
Okay.
Exactly. Yeah.
Yeah, that's good, because you see a lot of, fresh water getting pumped straight out of the green, and we have all kinds of issues with water right now, and so.
Exactly.
Good.
Yep.
Okay. Any other questions, board? Okay. Want to go back to division? Anything else?
No, nothing from the division. But are we admitting the exhibits?
Well, I was going to get to that, but yeah. Okay. Mr. Chicken, go ahead.
I'd like to admit exhibits A through R to the record.
Okay.
And in closing, I would just ask that the board approve the RAA as requested, and establish the various laydown 1920 and 2560 acre DSUs and various 3840 and 5120 acre section line DSUs with the mentioned 100-foot heel toe, 330-foot boundary line, 100-foot inner well setbacks, and well density of 16 wells.
Okay, thank you. Division?
On February 10th, the division filed a response to request for agency action. I should have put response to request for amended agency action, but that response does reflect the procedural posture of this case with the withdrawing of the original RAA.
The amendments.
But in any event, the division has no opposition to the board in granting this request. The division believes that the petitioner has met the statutory and regulatory requirements to seek the order that they are seeking today.
Okay.
Thank you very much.
Okay, board.
Mr. Chairman, could I ask one more kind of general question before we vote?
Yes.
And this is probably for Mr. Nielsen or maybe even the division. Has the city of Duchesne aware of your drilling underneath the city, and do they have any concerns about that? Have you had any correspondence or conversations with the city?
Yeah, we've got no concerns from the city. We've spoken with several people in the city area, the mayor of the city.
Okay.
Have gotten no concerns in that regard.
And division, have you had any correspondence about the city?
No, we have not.
Thank you.
Okay.
I just, on that, I did have some questions about the flaring, and I let them know that, it's all being gone through the process and things, and so there was some notice of that, but otherwise in Duchesne, very supportive of what WEM is doing, and so.
I appreciate it. Thank you.
Okay. Okay, board, do we want to deliberate?
I'm good.
I think, looks like everybody's good. All right. Call for a motion then?
I move to grant the RAA as presented.
Second.
Okay. Motion's been made and seconded to approve the request for agency action as requested. All those in favor say aye.
Aye.
Any opposed, say nay. Hearing none, the motion is approved unanimously. Also want to add, certainly appreciate you staying ahead of the game on the flaring. That will make things a little bit shorter in the future, too. Okay. With that, we will take a... Oh, Mr. Chicken, will you prepare the order, please?
I will, Mr. Chair, thank you.
Yeah, and on both of those cases, let's try to get those wrapped up before the end of next week, if possible. Okay? And with that, we'll go on a break. Let's go for 25 minutes. Is that okay? Okay, so we'll be back on the record at 12:45. We'll take a 25-minute break. Thank you.
One.
Good afternoon, everybody. We're back on the record, and we're going to pick it up with agenda number 9, which is docket number 2026-011, cause number 130-48. In the matter of the request for agency action of 4 Points Resources, LLC, for an order establishing an overlapping stand-up vertical 2,569.59 acre drilling unit for extra long lateral horizontal wells for the production of oil, gas, and associated hydrocarbons from the lower Green River Wasatch formations comprised of sections 3, 10, 15, 22, and 27, Township 4 South, Range 2 West, USM, Duchesne County, Utah, with certain caveats relating to existing wells thereon. Take appearances for the record.
Fred McDonald of Counsel with Lear & Lear on behalf of petitioner 4 Point Resources, LLC.
Okay. Thank you.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Thank you. Okay. Mr.
Thank you, Mr. Chairman. With me today, appearing virtually pursuant to the board's order on February 12th, are Mr. Clint Cook, the senior landman, Ms. Sarah Smaltz, the senior geologic advisor, and Mr. Brett Kovach, the senior reservoir engineer, and I would ask that the vice chairman swear them in at this time.
Would you please stand and raise your right arm to the square? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do. I do.
Maybe I don't need to have them stand.
Yeah.
Not virtually.
Throws off all their cameras. And also, my family does have mineral interest in this drilling unit, and it's all leased and held. Just wanted to disclose that and request to be able to participate in this hearing.
No objection from the petitioner.
Okay, division.
Yeah, no objections from the division.
Thank you.
Mr. Chairman, the resume of all 3 witnesses was collectively submitted as Exhibit A. If separately asked, each would verify the contents of their resumes are true and correct. Mr. Cook will be a fact witness only. Ms. Schmaltz and Mr. Kovach have been previously recognized by the board as experts in geology and petroleum engineering, respectively. Presuming the division has no objection, we would ask that they again be recognized as experts in those fields for purposes of this cause.
Okay, division.
No objections from the division.
Board, any questions about expertise? Seeing none, go ahead and proceed.
Thank you. Also, I will be moving for admission of our exhibits at the end of our presentation in chief. Members of the board, 4 Point is before you today seeking establishment of a 2586.59 acre stand-up drilling unit for extra long lateral, being 20,000 foot well development of the lower Green River Wasatch formations, comprised of sections 3, 10, 15, 22, and 27 of Township 4 South, Range 2 West in Duchesne County. Section 27 is included because it's a partial section comprised of 4 lots only, due to this UNA special meridian, and that was intended so that the resources under those lots would not be stranded. Okay. The board previously established these lands as 2 separate stand-up drilling units pursuant to the order entered in cause number 139-150, being comprised of sections 3 and 10 and sections 15, 27, and 22, respectively. A true and correct copy of the 139-150 order was submitted as Exhibit B in this cause, as part of it. Prior to entry of the 139-150 order, Newfield, which was 4 Point's predecessor, drilled 7 vertical or directional drilled wells and 1 short lateral, being 5,000 feet, horizontal well. After the 139-150 order was entered, Newfield, later Ovintiv by name change and merger, drilled 2 long lateral, which are 10,000 foot wells. As a consequence of those 2 lateral wells, the previously drilled wells converted to production allocation on the respective 2-section or 3-sectional drilling unit basis established and pursuant to the 139-150 order. As the board is aware, and you've heard this morning, the trend in the Uinta Basin is now to drill up to 20,000 foot wells. 4 Point desires to drill a 20,000 foot well development on these particular lands with authorization to drill no more than 40 total of 10,000 foot or 20,000 foot wells combined on the existing drilling units and the newly requested drilling unit. In other words, there's just going to be 40 long lateral horizontal wells. 4 Point will maintain the 100-foot heel-toe setbacks and 560-foot perpendicular setbacks established under the 139-150 order as modified by the board's 130-09 order. However, it does not desire to disrupt existing rights to production currently established under the 139-150 order, and therefore seeks that the requested drilling unit overlap and not result in any additional conversion. Even though this well will be an overlapping drilling unit, 4 Point is requesting no inner well setbacks between the existing wells and the newly drilled 20,000-foot wells. As the testimony will show, owners of the correlative rights in those existing wells actually benefit from the 20,000-foot wells by uptick in production and ultimate economic recovery of resource. Furthermore, as you know, no inner well setbacks is the trend now, more recently in the Uinta Basin. For example, the cause number order entered in cause number 13044 entered in December. A true and correct copy of the 13044 order was submitted as the remainder of Exhibit B in this cause. Since tribal minerals are involved, a new communization agreement will be required, and the federal agencies, whether under federal guidelines or by practice, require a spacing order of the board for such communization agreement to be approved. This is another reason why 4 Point is before you today. The board has jurisdiction over this matter pursuant to Utah Code Sections 40-6-5, subparagraph 3B, and 40-6-6. Notice was sent via regular mail to all production interest owners within the newly requested drilling unit and to the Ute Tribe, Ute Distribution Corporation, Bureau of Indian Affairs, and Bureau of Land Management due to the Indian ownership. The mailings were sent to these parties at the last addresses disclosed by the relevant BIA and Duchesne County Realty records. In addition, notice of the filing of the request in this hearing was duly published in the Salt Lake Tribune on February 1st and in the Uinta Basin Standard on February 4th, 2026. On February 10th, the Utah Division of Oil, Gas, and Mining filed a response expressing no opposition to the granting of the request, presuming 4 Point meets its burden of proof at today's hearing, which we will do. No other objections or responses to the request were timely filed, and no other party has made an appearance here today. With that, I'll commence my examination of Mr. Cook. Mr. Cook, would you please state your name and business address for the record?
Yeah, Clint Cook, 4 Point Resources, LLC. It's 100 St. Paul Street, Suite 400, Denver, Colorado.
And what's your current position with 4 Point, and how does it relate to this drilling unit at issue today?
I'm senior landman overseeing the DSUs at issue.
All right, for the record, would you please state 4 Point's corporate and bonding status?
Yes, 4 Point is a Delaware limited liability company with its principal place of business in Denver, Colorado. It's a successor by assignment to Ovindiv USA Inc., successor by name change, and merger to Newfield Production Company. 4 Point is duly qualified to conduct business in the state of Utah and is fully and appropriately bonded with all the relevant state of Utah agencies.
All right, Mr. Cook, I'm going to show you, hopefully you can see the PowerPoint, and I know you have the copies of these exhibits in front of you. Exhibits C through H. Do you recognize these exhibits?
I do.
Were they prepared by you or 4 Point personnel with your review and input?
Yes.
All right, starting with Exhibit C, would you please explain to the board what this shows?
Sure. Exhibit C's regional locator plat showing the DSU at issue. You can see it's approximately 2 miles southwest of the Mighton town site and a mile south of US 40.
All right, turning your attention now to Exhibit D. This is a 2-page exhibit. Starting with Exhibit D1, please explain what this shows.
D1 reflects the 2 DSUs that currently exist under the 139-150 order.
All right, and now D2. Again, please show what that please explain what that shows.
D2 reflects the new 4th section or 2,586 plus acre proposed DSU for the XLHZ wells. And it also shows our notice area for this RAA.
All right, and it's just to clarify, it's 5 sections because of that partial section 27,
Correct.
right?
Yeah.
Okay, all right. Yeah. Now turning your attention to Exhibit E, would you please explain what this shows?
Sure. Exhibit E is the mineral ownership type plat with the tribal minerals shown in green, and the remainder in yellow there is all fee minerals. There is no state minerals in this DSU.
All right, when you have tribal minerals involved, what are the requirements of the federal agencies with respect to pooling or communitization?
Sure. So whenever there's tribal minerals involved, we're required to get a spacing order in order to facilitate the approval of a communitization agreement with the BLM and BIA.
All right, now turning your attention to Exhibit F, would you please explain what this shows?
Yep. Exhibit F is just indicates 4 points working interest within the DSUs at issue, showing a clear majority interest in both DSUs.
All right, turning your attention to the last column, you have partner unleased, and I know that the board is interested. How much of this acreage is, or the percentage of these drilling units is actually unleased versus a partner that is signed a JOA and designated 4 Point as the operator?
Sure. So for both of these, it's less than 1% in each of them that is truly unleased interest and not partner interest.
Okay, now turning your attention to Exhibit G, would you please explain what this shows?
Yep. Exhibit G just shows the existing wells within the proposed DSU.
And as relevant to those wells, now turning your attention to Exhibit H, would you please explain what this shows?
Yep. Exhibit H shows all of those existing wells and how they will remain on their existing production allocation schedule as provided in Order 139-150. Consequently, there will be no conversion that happens under this proposed DSU.
Because it's an overlapping drilling unit, correct?
That's correct.
All right, now I'm going to ask you to turn your attention to the certificate of service. This is a pleading that was provided by my office and is on file. You should have a hard copy in front of you of that. Do you recognize that document, and who are those parties, and how were the names and addresses derived?
Yes, I recognize these. There are the owners of production interests within the subject DSU, and those parties and addresses were compiled from 4 Point's internal land records, including title opinions, division of interests for each of the wells we operate in there, as well as a search of the BIA and Duchesne County records prior to filing the RAA. And this work was conducted by Lone Wolf Energy, Inc., who is our contracted land services company.
Okay, and for the board's information, since the setbacks are not changing from what they currently are, there was no need to notify adjacent drilling unit or working interest owners in adjacent units. Is that correct?
Yes.
All right. There's no Exhibit Z again because this was mailed out regular mail, so there's no certified mailing return receipts on this one. With that, that concludes my examination, Mr. Cook.
Okay, division.
Thank you. Just for clarification, this new unit that is being requested today, is it only for extra long horizontals? Or greater than 3 miles? Okay, so anything less than greater than 3 miles will go under the existing 1280 DSUs, is that correct?
Yes, that's correct.
And then on Exhibit G, you don't have to show it, but we have it's right there too, all the existing wells. Does 4 Point operate all the existing wells?
Yes, we do.
Okay. Thank you. No further questions.
Okay. Division, do we have any questions? Yeah, I'm sorry, board, sorry.
Yes, Mr. Cook, just to clarify in my mind, so there's an existing 1 mile well, 1 2 mile well, and 1 3 mile well that you have drilled in these lands so far?
Well, Matt, could-
I believe, oh, go ahead.
there we go. Go ahead.
I believe there's two-mile wells, one going through section 10 and 3, and one going through 15, 22, and 27, and then a 1-mile well in 15.
Oh, okay. And so you were asking now for 40 additional wells, or not to exceed 40, including these 3 wells?
I believe that's right. I'll defer to Fred on the exact mechanics of that.
What they were asking for in the request was not to have a total of 40 wells, either at 10,000 foot or 20,000 foot.
Okay, so
that's all the total amount of long lateral horizontal wells would be no more than 40.
okay, that clarifies it. Thank you.
Anything else, board? Okay.
Thank you, Mr. Chair. With that, I'll commence my examination of Ms. Smaltz. Ms. Smaltz, would you please state your name and business address for the record?
Yes, Sarah Smaltz, 4 Point Resources LLC, 100 St. Paul Street, Suite 400, Denver, Colorado 80206.
And what is your current position with 4 Point, and how does it relate to this drilling unit at issue?
Yeah, I'm the Senior Geologic Advisor overseeing long-term development plans and overseeing this DSU at issue.
And I'm going to turn your attention to what have been marked as Exhibits I, J, and K. Hopefully you can see them on the PowerPoint, or you have the hard copies in front of you. Were these prepared by you or 4 Point personnel with your review and input?
Yes, sir.
All right, turning your attention to Exhibit I, would you please explain to the board what this shows and its significance to today's hearing?
Yeah, on Exhibit I, the map is highlighting the location of the proposed DSU in relation to the field type log, the Shell-Brotherson 1-11B4, which has been used and recognized in numerous orders, including the 139-150 order, and you just saw it in one of the previous causes as well. And then on the left, the stratigraphic interval, which is defined as the lower Green River to Wasatch transitional formations, is highlighted on the type log.
Now turning your attention to Exhibit J, same question. What does this show, and how is it significant to today's hearing?
Yes, Exhibit J is displaying a type log that's located just to the north of the DSU at issue. This is the Moon ON 1-27-3-2, and it's highlighting the primary target intervals for the area, which would also be the target intervals for any 20K wells that may be proposed within the subject DSU.
And finally, turning your attention to Exhibit K, again, what does this show, and how is it significant to today's hearing?
Yes, Exhibit K is a north to south stratigraphic cross-section through the DSU, including the local type log from the previous exhibit. This cross-section reflects that these primary target formations have uniformity across the area, which makes this unit conducive to 20K development. And it is also highlighting that the lower Green River to Wasatch transitional formations constitute one source of supply in the area and is consistent with the board's designation of those formations as one pool throughout the Uinta Basin.
All right, just to reiterate then, is it your expert opinion that the uniformity and thickness make the lower Green River Wasatch an attractive target for 20,000-foot well development?
Yes.
Is it also your expert opinion that the lower Green River Wasatch constitutes one common source of supply throughout this requested drilling unit?
Yes, sir.
All right, that concludes my examination. Ms. Smaltz?
Thank you.
Thank you. I don't have any specific questions, but Megan Crocker from the division has a question with the board's permission.
Sure.
If you want to go to Exhibit G, I was wondering if you were planning on doing a J-shaped well in sections 15 and 22, since there's a spot pattern open there, and then which would you utilize, the underlapping 12 or the 1280, or do you use the longer spacing since it's overlapping?
At this time, we do not have plans to drill a J in 15 and 22. That's something that could still be on the table pending finding the appropriate surface location. Right now, we do have plans to drill a mix of 10K and 20K wells in the existing units. As you can see, the Knoll UT 5H that's located in 15 and 22 has a slot open to the north of it in 3 and 10. So we want to maximize resource recovery. So we do plan to drill a 10K within 3 and 10. And then on the east side of the unit, we do plan on drilling 20K laterals. So we would need an additional surface location in 10, around that section line between 10 and 15 to drill a J, most likely. A 25,000 foot J has not been done. We just finished our first 15,000 foot J. So we will see how the 20K wells go before we broach going perning at the end of 20Ks.
Great, thank you very much.
Mm-hmm.
Thank you. Nothing further from the division.
Okay, thank you. Board, do you have questions for Ms. Schmaltz? Go ahead, Gordon.
Yeah, so just tell us a little bit more about the J wells. I've noticed a few of those being drilled. Do you have any producing now, and how are they doing?
We are currently completing our first 2 J laterals. So we don't have the results yet on those. They're in the middle of their completion, but we did successfully drill those 2 TD to the plan that was permitted. And we are very excited about that. As a follow-up to that, we have sundried another well further to the west in one of our DSUs that we currently have a rig on to another J lateral. So we will continue to look for those opportunities throughout our position to take advantage of that, since at least we have so far been able to successfully execute those on the drilling side. And we will be keeping obviously a close eye on how they produce once we get them completed, drilled out, and start flowing back.
Is there any way to do a J well in different horizons, or do you have to be in the same horizon and do it at the same? Does that make sense?
Yeah, I see what you're saying. We have not looked into that yet. Our first 2, we kept them within the same target interval. So one was a Uteland Butte and one was a Wasatch. So we have tried it in 2 different formations so far successfully. If there was an opportunity where we had to jump to a different target, we'd have to really take that into strong consideration, because there are, potentially lithologies that we'd be drilling through that could be unstable depending on the direction that you're drilling through. So there'd be a lot of work up front that would need to be done to ensure the wellbore is stable if we were jumping from one formation or one target to another.
Thank you. Thank you.
Okay, I have a question on Exhibit G of work. In the north end of Section 3, you've got depiction of, looks like, are those the drilling locations in the north end of 3 that go into 27 and 34 up there?
Yeah, there is a pad there
Uh-huh.
in Section 3 that was utilized to drill wells to the north in Section 34 and 27. Those are our Akawana wells that we drilled, and they're currently on production. At the moment, the current development that we are planning for this requested DSU would actually be off of that same pad. We would be drilling north to south.
Okay. Okay, thank you.
Oh, another quick question. So when you get longer, are your north to south wells more efficient than your south to north wells because of the difference in the angle?
I have not done that study across our position to see if there's significant differences if you're drilling down dip or up dip. So I don't think I can answer that at this time.
But it's not a big consideration then when you're looking at locating well pads.
We have not taken it into significant consideration. I think oftentimes we would prefer to be able to drill down dip rather than up dip. Just I think as previous colleagues from other companies were noting, it's nice to have that additional weight behind you when you're drilling versus drilling up dip. You're sort of pushing that pipe up dip in a sense. But surfaces are precious out here, And so sometimes you don't necessarily have that luxury to determine whether or not you're going to drill up dip or down dip.
Okay. Yeah, that makes sense. It'd be easier to drill and complete down dip, but I would think that up dip would be more efficient to produce because you got it flowing back to the vertical wellbore.
Mhm. Yeah, that's a study that I don't think that we've completed since we've taken over the asset, but might be one worth looking into.
Okay. Thank you.
Okay. Board, any other questions? Okay. Mr. McDonald, please.
Thank you, Mr. Chairman. With that, I'll commence my examination, Mr. Kovach. Mr. Kovach, would you please state your name and business address for the record?
Yes, it's Brett Kovach, and address is 100 St. Paul Street, Suite 400, Denver, Colorado 80206.
And what is your current position with 4 Point, and how does it relate to the drilling unit at issue?
Yes, senior reservoir engineer overseeing the DSUs at issue.
Okay, I'm going to direct your attention to what has been marked as Exhibit L. Hopefully you see that on the PowerPoint or you have the hard copy in front of you. Was this prepared by you or 4 Point personnel with your review and input?
Yes, it was.
Okay, would you please explain its significance to today's hearing?
Yes, this is a similar exhibit to what we've shown historically, but historically we've shown it for the 3 mile well relative to the 4 mile well shown here. And really what we're showing here is that as you go from 2 miles to 4 miles, you're generally going to see a really attractive cost per foot decrease of around 20 to 22%. And with that, we do not expect to see any material degradation to the performance per foot. So when you couple kind of performance scaling 1-to-1 with cost decreasing by 22% per foot, this results in a much more resource recovered per dollar of capital invested.
All right, could you, just to clarify again, what Mr. Church had asked about can you confirm that 4 Point is just interested in drilling a total of 40, either 10K or 20K wells together?
Yes.
All right. Could you also address the request asked for no interwell setbacks with the existing wells? Again, could you kind of address that? You've done it in previous hearings, but kind of reiterate it for purposes of this cause.
Yeah, so as the board found in the 130-44 order, and as we've kind of shown in recent testimonies as well, really what we've seen is that there's generally been an uplift in performance to kind of existing wells when a new 10K well is drilled nearby. And we don't have any reason to believe that a 20K would be a different scenario than the 10Ks.
All right, and again, just to reiterate, what steps do you take when you're drilling a well like that close by to the existing wells for the protection of those wells?
Yeah, so we'll, do detailed anti-collision work prior to drilling and detailed steering work and be monitoring it the entire time. And then while completion, we'll be shutting in and monitoring pressures as well.
All right, so is it your expert opinion then that up to 40 wells, whether 10,000 foot or 20,000 foot or a combination of both, may be required to recover additional resources in both the existing drilling units and the requested drilling unit, which would otherwise be left in the ground?
Yes.
Is it also your expert opinion that a 20,000 foot well appear more economic than the 10,000 foot wells?
Yes.
Is it also your expert opinion that the elimination of interwell setbacks between existing wells and newly drilled 20,000 foot wells in general would benefit rather than harm the correlative rights of the owners in those existing wells and is consistent with other practices in the Uinta Basin?
Yes.
Mr. Chairman, that concludes my examination of Mr. Kovach.
Okay. Division?
Thank you. Mr. Kovach, there's no exhibit, or we haven't really talked about how generally 40 wells would look in this unit. Could you just give us an idea of where the number 40 comes from and why you picked that density?
Yeah, so I think the 40 gives us room for the 10Ks in kind of both the DSUs as well as the 20Ks that we plan to do. And really, I think when we think about this area, there still needs to be, delineation of some of the upper benches and kind of what the density looks like in those and, where those work in 10K versus 20K. I think there's, still things to be sorted out on that front. So I think that would probably be the 40 would come from obviously the kind of lower cube wells, but also the upper cube wells, the Douglas Creek and Garden Gulch as well.
And so do you have any thoughts on, and maybe I'm expressing this incorrect, but like how many wells would you have per a horizon or formation?
Yeah, I probably wouldn't expect to be putting more than, 8 per horizon. I think like if you think about the Uteland Butte, there's not very many places where you'll find more than 8 per section in that type of range.
All right. Thank you. No further questions.
Okay. Board members, questions, Mr. Kovach?
Yes, Mr. Kovach. So as you do kind of wine rack drilling here, and you go into the deeper horizons in the Wasatch, are you looking at a higher gas oil ratio the deeper you go?
Yeah, I mean, generally, I think when you look at the kind of initial GORs in the basin, you'll tend to see a trend where your initial GOR rises from east to west. And, then kind of as you also move from east to west, like as your GOR rises, what you'll see happen is your headspace metric also goes lower. And headspace is representative of the kind of delta in pressure between initial reservoir pressure and saturation pressure, where gas starts to evolve out of solution. But what you don't tend to see between, the Uteland Butte, the Castle Peak just above it, or the Wasatch just below it, is dramatic differences in initial GOR. You might see small differences, but they don't tend to be huge. You aren't talking like in the Permian. You might see really big differences between benches as you go lower stratigraphically, but we haven't seen evidence of that here.
Thank you.
Other questions from the board? I don't see any questions. Okay.
Thank you, Mr. Chairman. That concludes our presentation to Chief. At this time, I would move for admission of Exhibits A through L inclusive.
Okay.
And with that, I'll reserve closing after the division's comments.
Okay.
Thank you. The division just has short comment. We reviewed the RAA, we reviewed the exhibits, and we listened to the testimony here today. And based on what's being presented, the division has no objections to the granting of this request. Thank you.
Okay. Thank you. Okay. Board, do we have any questions before we?
Do we want Fred to give his closing?
Yeah. I'm gonna do that just- Okay. Okay. Mr. McDonald?
Thank you, Mr. Chairman. With that, we believe we've met the statutory and regulatory requirements. We would ask that the board approve the request as submitted. And thank you for your time, and especially the IT people for allowing the witnesses virtual participation.
Appreciate it. Okay. Okay, so division, our board, I'm sorry. Do you want to deliberate on this, Phil? No? Okay, so I think, let's go ahead and entertain a motion.
I move that we approve the request for agency action.
I'll second.
Okay, a motion's been made and seconded to approve the request for agency action as submitted. All those in favor say aye.
Aye. Aye.
Any opposed, say nay. Okay, it's unanimous. Mr. McDonald, would you prepare the order, please?
Certainly, and I'll do it in a timely fashion, too.
Yeah, we're looking at,
Right, at a week.
within a week or so.
Yep,
Thank you.
will do.
Okay. All right. So we are to item on the agenda, item number 10. Looks like, sorry? Oh. Okay.
Herschel, Sanders, and then Horner. Right.
We okay to start, Mr. McDonald?
Yes.
Okay. Okay, docket, docket number 2026-013, cause number 470-25. In the matter of the request for agency action of Uinta Wax Operating LLC for an order partially amending the board's order entered in cause number 131-151 to modify the stratigraphic definition of the spaced interval as pertaining only to the drilling unit established thereunder for long lateral horizontal wells comprised of sections 3 and 10, Township 3 South, Range 1 East, USM, Uinta County, Utah. Appearances?
Fred McDonald of Counsel with Lear & Lear on behalf of petitioner Uinta Wax Operating.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Okay, thank you. Go ahead, Mr. McDonald.
All right, Matt, could we have the witnesses on the screen?
Yeah, stand by.
Thank you.
Mr. McDonald, it looks like we're short one.
No, there's just the two witnesses
Oh,
on
just the
this
two.
one.
Okay, thank you.
All righty. Members of the board with me today, virtually pursuant to your February 12th order, are Mr. Herschel Saunders, the senior landman of Uinta Wax LLC, and Mr. Robert Horner, the senior geologist of Uinta Wax LLC. Both share duties with the petitioner, Uinta Wax Operating, and I would ask that they be sworn in at this time by the vice chair.
Would you please bring your right arm to the square? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Herschel, you're on mute. If you could unmute.
I read his lips.
Great. Okay, thank you.
Sorry about that.
No worries. Members of the board, the resumes of the witnesses were collectively submitted as Exhibit A. If asked, each would confirm that they are true and correct, of their information on there is true and correct. Mr. Saunders will be a fact witness only. Mr. Horner has been previously recognized as an expert in geology by the board, and presuming the division has no objection, we'd ask that the board again recognize him as an expert in that field for purposes of this cause.
Division, any issues?
No objections.
Board members, any issues? Okay, thank you. Go ahead.
Thank you. Also, I'll be moving for admission of the exhibits at the end of the presentation in chief. Members of the board, today, Uinta Wax Operating is before you seeking partial amendment of the board's order entered in cause number 131-151 to expand the stratigraphic definition of the formation space to include additional anticipated productive zones of the Green River Formation above the TGR3 marker as relating to the drilling unit for 10,000-foot wells comprised of sections 3 and 10 of Township 3 South, Range 1 East in Uinta County. A true and correct copy of the 131-151 order was submitted as Exhibit B in this cause. As the testimony will reflect, Uinta Wax Operating believes these shallow zones constitute a common source of supply with the previous space formations and therefore seeks to test the productivity of 10,000-foot wells within that zone. If successful, Uinta Wax Operating may seek similar modification of the space formation definitions across this portion of the field. The 131-151 order was previously modified by the board's orders entered in cause number 470-03 for setback reductions and 470-12 increasing the authorized number of 10,000-foot wells to 36. No further modifications to the 131-151 order as so modified are being sought today other than to expand the spaced interval. I need to note a correction to the request for agency action. Specifically in the request, it was stated that there was no 10,000-foot wells drilled on the drilling unit. However, as Mr. Sanders will testify, there are actually 4 10,000-foot wells on the drilling unit currently in drilling status as authorized under the 131-151 order as previously modified, but which have not yet begun to produce. Specifically, 3 are being drilled within the existing 131-151 spaced intervals, and 1 is being drilled within the requested expansion zone under an exception location approval from the division. That well will not be completed until after this hearing, presuming the board approves the request for agency action. The board has jurisdiction over this matter pursuant to Utah Code sections 40-6-5 subparagraph 3B and 40-6-6. Notice was sent via regular mail to all production interest owners within the subject drilling unit and to the Bureau of Indian Affairs, the Vernal Field Office of the Bureau of Land Management, since it's the technical consultant to the Bureau of Indian Affairs, the Ute Indian Tribe and the Ute Distribution Corporation due to allotted mineral ownership, and to the School and Institutional Trust Lands Administration due to state mineral ownership. The mailings were sent to these parties at their last addresses disclosed by the relevant agency and Uinta County Realty Records. The record will also reflect that the notice was duly published in Salt Lake Tribune on February 1st and in the Vernal Express and the Uinta Basin Standard on February 4th. On February 10th, the division timely filed a response to the request, stating that the division does not oppose the granting of the relief requested, presuming Uinta Wax satisfies its burden of proof today. as the testimony will reflect, will sustain that burden. No other objections or responses were timely received, and nobody else has made an appearance here today. With that, I'll commence my examination of Mr. Saunders. Mr. Saunders, would you please state your name and business address for the record?
Herschel Sanders, 6000 Western Place, Suite 1000, Fort Worth, Texas, 76107.
And what is your current position with Uena Wax Operating and Uena Wax LLC, and how does it relate to this drilling unit?
I'm a senior landman for Uena Wax, and I have supervision over the DSU at issue today.
All right, for the record, would you please state the corporate and bonding status of Uena Wax Operating?
Uena Wax Operating is a Delaware limited liability corporation. We're in good standing, and its principal place of business is in Fort Worth, Texas.
All right.
Uena Wax Operating is duly authorized to conduct business in the state of Utah and is fully bonded with all relevant state of Utah and federal agencies. It's the designated operator on behalf of Uena Wax LLC.
All right, Mr. Saunders, hopefully you can see the PowerPoint. If not, I know you have the hard copies in front of you. I'm going to show you what have been marked as Exhibits C through E for purposes of this cause. Do you recognize these exhibits?
I do.
And were they prepared by you or Uena Wax personnel with your review and input?
Yes, they were.
Starting with Exhibit C, would you please explain what this shows?
Exhibit C is a locator map showing the DSU at question being located approximately 3 miles southeast of Fort Duchesne and 2 miles west of Randlet. And this map also represents our notice outline. Any production owners inside the red box were notified.
Okay, now turning your attention to Exhibit D, please explain what this shows and its significance to the hearing.
Exhibit D is a description of the mineral ownership in the DSU, with the green being state minerals and the orange are allotted minerals and the blue are fee minerals.
And who is the majority working interest owner in this drilling unit?
Uena Wax has over a 94% working interest in this DSU.
Okay, and now turning your attention to Exhibit E, please explain what this shows.
Exhibit E shows the wells you mentioned earlier, as well as one short horizontal in section 10 that is operated by Uena Wax. And the remaining 4 are the 4 wells that are currently drilling, not yet completed, with one of those being in the zone that we're looking to add today.
And the one that is not in the, or is in the zone that you're looking to add today, do you agree or can you confirm for the record that that's not going to be produced or completed until after this hearing?
That will be correct.
All right.
We're not going to complete this well until after the hearing, the approval.
Okay, I'm now going to direct your attention to the certificate of service. You should have a hard copy in front of you. This is a pleading that's already on file that was prepared by my office. Do you recognize the names and addresses on there, and how were they compiled?
I do. These addresses were generated out of our accounting system, our land system, and through the county records, the BIA office, and our contract land service group for updates.
And are they all the production interest owners within the drilling unit, as you mentioned on Exhibit C?
Yes, these are all the owners in that red outline.
Production interest owners, so that'd be royalty override, all that. Yep.
All
Okay.
production interest owners, yes, sir.
All right, thank you. Again, the mailing was sent out regular mail, so again, there's no return receipts or an Exhibit Z that you're used to seeing here. With that, that concludes my examination of Mr. Saunders.
Thank you. Mr. Haynes?
Thank you. Mr. Saunders, I'm going to ask you, I don't know if this is a good question for you or for the next witness, but Could you tell me, are there any other wells in this unit, such as injection wells or any verticals or direction wells that weren't shown on Exhibit E?
No, sir.
No, sir. All right. All right, no further questions. Thank you.
Okay. Board members, questions? Okay, no more questions.
All right, thank you, Mr. Chairman. With that, I'll commence my examination of Mr. Horner. Mr. Horner, would you please state your name and business address for the record?
My name is Robbie Horner. My business address is 6000 Western Place, Suite 1000, Fort Worth, Texas, 76107. I'm a senior geologist for UNOX.
And are you also the geologist handling this drilling unit?
Yes.
All right. I'm going to show you what have been marked as exhibits F through H for purposes of this cause. Hopefully you can see it on the PowerPoint, or I know you have the hard copies in front of you. Do you recognize these exhibits?
Yes.
Were they prepared by you or UNOX personnel with your review and input?
Yes.
Okay, starting with exhibit F, would you please explain what this shows?
This is the type log from the BAP 624-21E, which is about 3 miles north and 3 miles east, so kind of 3 miles diagonally from the DSU's at section. It shows the stratigraphic definition contained in 131-151, and we are noting the depths of the TGR3 as well as the Mahogany, Wasatch, and Flagstaff.
So again, the expansion, just so the board understands, the expansion zone that you're asking is that on the far right, the difference between the TGR3 marker and the Mahogany bench marker?
Yes.
Okay. Now turning your attention to exhibit G, please explain what this shows.
This is a correlation between the BAP well and the Brotherson well. I'm sure the board is certainly tired of seeing the Brotherson well at this point. It is on the northwest side of the basin, and we're looking, correlating from west to east here, and noting that there are similar formations there, and we're just looking to add up the Mahogany zone into this definition.
All right. Is the Mahogany bench still considered part of the common source of supply for purposes of the resource?
Yeah, the Green River Formation as a whole actually considers or contains the Mahogany zone. The differentiation for it has historically been the resource as an oil shale, which is more common to the south. Petroleum systems are sort of agnostic to depth, and where we are, it is a target that is viable, and it's the same geology from the Green River throughout the Green River as a lacustrine system. So it's the same source, same supply.
All right. Finally, turning your attention to exhibit H, please explain what this shows.
This is the expanded gun barrel diagram showing a theoretical development model, keeping 36 up to 36 10K laterals that are planned.
All right. And if it's successful, do you anticipate using this similar model in other areas of the field?
Yes.
Okay. So your expert opinion then that the expanded interval constitutes a common source of supply with the existing space formations?
Yes.
Is it also your expert opinion that modification to expand the spaced interval limited to this drilling unit will allow the greater recovery of natural resources with associated greater economic benefit without waste and with protection of correlative rights?
Yes.
All right, Mr. Chairman, that concludes my examination. Mr. Horner?
Okay. Division?
Thank you. With the board's permission, Megan Crocker of the division would like to ask a question.
Sure.
Out of curiosity, since this is, there's some injection zones above the Mahogany bench, do you anticipate having any, interactions or any potential issues with water if you go through the Mahogany bench to upper zones?
Not here, but it depends on where you are relative to the basin. I mean, this is in this area, in this portion of the basin in Randolette, there's not that much development, so it's not something that we would anticipate for this.
Okay, so there's just not that many injection wells in this part of the basin.
That's correct.
Okay.
Not within reasonable distance of here, at least.
Okay.
Thank you. No further questions from the division.
Okay, board members, yeah, got questions?
Yes, Mr. Horner. So the exhibit that shows the cross-section, Exhibit G, I don't see a map, planar map of where those wells are located. So is the Bab well deeper in the basin than the Brotherson well?
Not necessarily. Taking a look at the depths on that, your mahogany zone on that Brotherson well is about 8,000 feet TVD. And the Bab well is around 7,000 foot TVD. And that's, the difference between measured depth and true vertical depth, or measured depth sort of your X, whereas your true vertical depth is going to be more of a Y. So relatively similar. They're pretty far apart. The Brotherson type well has been used time and time again throughout the basin in spacing hearings, with Shell having sort of initially established, as far as I've been able to understand it, the TGR3 is the top of the Green River in the subsurface. However, as stated, the actual Green River includes the mahogany as well.
Okay, I see between the two wells that the upper section and the mahogany bench is really thickening in the Bab well compared to the Brotherson well. So this is the upper section you're wanting to add. You've got I assume it's a thicker section, or is it?
Yeah, it's still a lacustrine portion of, a lacustrine system. So there's actually multiple members within the mahogany. There are lean and rich zones as they have mapped them, and much like the other intervals in the basin, the carbonate thick sections move around a little bit with the paleo shorelines. So depending on where you are, certain parts of the mahogany zone certainly are variable in their thickness.
Okay, so that leads me to this question. If you add this upper section and you're developing it in additional to the lower section that's already spaced for, the number of wells is very similar to what other operators ask for in developing the lower Green River to Wasatch. As to what you're asking to do the lower Green River and Wasatch plus the upper Green River, so are you reducing the number of wells in the lower two benches to make room for the development of the upper bench of the Green River if it's successful? Or will you at some point in time need to come back and infill and ask for a greater number of wells in this spacing unit?
Based on the success of this well, we'd certainly reconsider what our number of wells are. At 36, we feel that we're pretty free in terms of where we target, and we're not necessarily tied. We're tied to specific zones, but not necessarily, say all Long Points or all Castle Peak. But this is a first of its kind well that we've just drilled, and so depending on the results of it, we'd certainly consider. But at this time, we have no idea about how much drainage we have vertically or horizontally in this zone, and whether or not we would need to come in and add, say, another 10 wells or whatnot.
Okay, thank you.
Board members, other questions? Yeah, I have a question, Mr. Horner. How many mahogany wells have you encountered out in the basin? I haven't seen many.
Vertically or horizontal? Because it's been
horizontal.
Targeted horizontally, as far as I know, not any yet.
Okay, okay. All right. And also, let me ask on behalf of the board that the scale on the Brotherson well versus the Bab well, you've got about 1,000 feet per 3/4 inches over on the left and 1,000 feet and about 2 inches on the right. So we ought to try to make those scales similar in the future on exhibits like this, if you can.
Yeah,
because it's somewhat deceptive there as far as how thick the mahogany is there.
Yeah, in trying to keep continuous, with what we've shown previously for the Brotherson and going all the way down to the Mesa Verde, it is in the northernmost portion of the basin where the Mesa Verde is all the way down at 17,000 feet. So the Cretaceous on the east side gets a little bit shallower. It's why all that shallow gas works, or the deep gas works on the east side of the basin. So in trying to keep, continuity with what we've shown, that's where the delta and the thicknesses come from.
Okay, thank you.
Understood. Apologies.
Yeah. Okay. All right. Board, anything else? Okay, back to you, Mr. McDonald.
Thank you, Mr. Chairman. That concludes our presentation to Chief. At this time, I would move for admission of exhibits A through H inclusive.
Okay.
Any objection from the division?
No objection from the division.
Okay.
All right, with that, I would reserve any comments until after the division's made its presentation.
Okay, division.
Thank you. Yes, yet again, just a short comment. We filed a notice of non-opposition in this request. We reviewed the RAA, we reviewed the exhibits, and we've listened to the testimony here today. And based on the evidence, the division has no opposition to the granting of this request.
Okay,
Thank you.
Okay, Mr. McDonald.
Thank you, Mr. Chairman. Again, thank you for the opportunity to have the witnesses appear virtually. Again, we believe this is fairly straightforward. I think it's an interesting development that they want to test another bench and the possibilities of it. And again, that opens up more resource availability. With that, we believe that we've justified the requested extension of the spaced interval, and we would ask that the board approve the request as submitted.
Okay. Real interested in seeing you go beyond the sweet spots we've got out there. So good. Board, any cause for deliberation? Seeing none, entertain a motion.
I move that we accept or approve this request for agency action.
I second.
Okay, motion's been made and seconded to approve this request for agency action. All those in favor say aye. Aye.
Aye.
All opposed say nay. Hearing none, that's unanimous. If you could please prepare the order.
I will, and I'll make sure it's timely submitted to council and to the board.
Mr. McDonald.
Thank you.
Thank you to the witnesses. All right.
Thank you.
Thank you.
Thanks, Andrew.
Okay, we're going to switch attorneys here now, Matt. Mr. Mayo, you're batting cleanup today. Sorry? Yeah.
Still live, so we can start whenever you're ready.
All right, while Mr. Mayo's getting set up, I will go ahead and read the docket. Okay, we're on docket number 11. So this is docket number 2026-015, cause number 130-49. In the matter of the request for agency action of SM Energy Company for an order amending the board's orders in cause numbers 139-153, 600-04, and 130-31 to establish A, 2 overlapping 4-mile, 2,560 acre DSUS, and B, 1 overlapping 4-mile, 5,120 acre DUB WDSU, each for producing oil, gas, and associated hydrocarbons from the lower Green River Wasatch Colton Formation in sections 7 to 10 and 15 to 18, Township 2 South, Range 3 West, USM, all in Duchesne County, Utah. Take appearances for the record.
Thank you, Mr. Chair. Mitch Mayo of Lear & Lair, PLC, on behalf of the petitioner, SM Energy Company.
Thank you.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining.
Thank you, Andrew. Go ahead, Mr. Mayo, when you're ready.
Thank you, Mr. Chair. One more minute while I get this screen connected. Let's see. I guess I can go a little bit while I'm here. With me today, are Rick Harris, head of land, regional land manager for Utah, Miss Katie Ross, the asset geology manager, Utah, and Brad Peterson, the Utah region asset manager. Could we please have these three witnesses sworn in at this time?
Would you please raise your right arm to the square? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth? So help you God. Thank you.
Thank you. It looks like it's up on the screen if everyone
There.
can see. Okay. The resumes of these three witnesses have all been submitted as part of petitioner's exhibit number 1. If separately asked, they would confirm the accuracy and completeness of those resumes. Each of these witnesses, though, have been recognized as an expert by this board several times, including last month in Cause 130-46, and with presumed stipulation from Division Counsel, we'd like to have them recognized as experts in their respective fields for this cause.
No objections.
Board, any questions or issues? Okay, so be it.
Thank you. Also, I will be moving for the admission of all the exhibits at the end of my case in chief. It's been a long day for the board, but this matter is actually going to be fairly straightforward. The request before you represents just an extension of what SM has been doing here in the basin for the last little bit. The subject lands are currently spaced by the board for overlapping units, 1 mile, 2 mile, and 3 mile units, including boundary line wells as well. And today the request is simply to add another overlap to that, to space this to include 4 mile units and the accompanying section line well, the Dubwood DSU that we all hate so much. The relief requested today, as mentioned by the chair, requires the modification of 3 orders, Order 139-153, Order 600-04, and Order 130-31. Those I may call the current orders. They collectively cover the sections 7 through 10, 15 through 18 of 2 South, 3 West, the subject lands. As of the date of filing of the request in this cause, there are 10 wells on the lands that are producing or capable of production, and SM operates all 10 of those wells. In short, SM believes that approving the request before you today will help them to kind of continue to set up the asset in a way to be developed into the future. The board has jurisdiction over this cause pursuant to Utah Code 40-6-5 and 40-6-6. Notice was provided as required under Utah law to all interest owners, all relevant governmental agencies, and to all offset operators as required. Each of these mailings was sent either to the address provided by the governmental agency or to the last known addresses of record in the office of the Duchesne County Recorder. In addition, notice was published in the Salt Lake Tribune and the Uinta Basin Standard on February 4th, 2026. Last thing to note, no one filed a protest or timely appeared in this matter, and I've been contacted by no one regarding a protest here. The division filed a notice of a response and notice of non-opposition on February 9th or 10th. I'll let them clarify that for the record, stating that the division does not oppose pending the presentation of evidence and testimony here today. And with that, I will jump into my examination of Mr. Harris. Can you begin by stating your name and business address for the record?
Yeah, my name is Rick Harris, or Richard Harris. Business address is 1700 Lincoln Street, Suite 3200, Denver, Colorado 80203.
Thank you. And what is your current position with SM?
You called me the head of land earlier, but no, I'm a regional.
That's what I call you.
Yeah. I'm the regional land manager of Utah.
Okay.
For SM Energy.
And it's safe to assume you exercise a supervisory role over the land records associated with the subject lands?
Yes.
Okay. Could you please provide for the record the corporate and bonding status for SM?
Yeah, SM is a Delaware corp in good standing, having its principal place of business in Denver. We are fully bonded with all the relevant federal, state, and tribal entities in state of Utah.
Perfect. I'd just like to remind all that Mr. Harris will be testifying as an expert in petroleum land management. And with that, I will start with your exhibits. There's a couple of exhibits that lay out the confusing nomenclature and help explain it. But without questions, I will just move straight to our substantive exhibits. I'm going to show you what's been marked and filed as exhibits 3 through 11. Do you recognize these exhibits?
Yes.
And were they prepared by you or by SM contractors or personnel under your direction or supervision?
Yes.
Okay. Switching back, we're going to start with exhibit 3. Board knows what this is, but please explain to them where the lands are relative to the basin.
Yeah, this is a locator map showing the lands that we're talking to today, outlined in yellow. And Township 2 South, Range 3 West, and Duchesne County. We're about 10 miles west of the city of Roosevelt.
Okay. And I probably didn't prepare you for this, but what is the red box and why is that on there? Maybe you can kind of give them an idea.
Sure. The red box is the area that we acquired from XCL last year, XCL Asset Co., and that's kind of just our principal operating area in the basin.
That's not the full extent of your ownership.
No, we have ownership to the north. We have ownership all around there, but that's the main operating townships that we're currently drilling out. Currently running 3 rigs.
Okay, thank you. Turning to exhibits 4 through 7, we're going to handle these as a batch. Exhibit 4, 5, 6, and 7. Now, I mentioned at the start of this that this request isn't asking for any changes to the 2 and 3 mile spacing. Can you confirm that to be true?
That's exactly right. Today we're just asking to add 1 mile onto these existing maps that are these exhibits 4 through 7, I think.
Okay, so could you briefly just, 1 or 2 sentences explain what exhibits 4, 5, 6, and 7 show?
Yeah, exhibit 4 is showing the existing 2 mile spacing in these 3 townships that we were talking about earlier.
And the lands at issue are here.
That's exactly right, yes.
Okay. Exhibit 5?
Exhibit 5, this is the lease line well, larger spacing units for lease line wells in those 3 townships that we've currently spaced. So as you can see on all of these, we're getting close to not having to come in these 3 townships. We're about close to having the whole thing spaced for our development. So
yeah,
that's what we're going for.
That's what they keep telling me.
Yeah, and then we keep thinking of stuff.
Exhibit 6, same thing.
Exhibit 6 shows the 3 mile units.
Okay.
And then 7 would be the overlapping lease line wells for our 3 mile units.
Okay. So exhibits 3 through 7 just show the 2 mile and 3 mile development that's currently authorized on the lands.
That's correct.
Okay. Exhibits 8 through 11, we'll talk about these together as well, but we'll take them one at a time. Exhibit 8 and 9 go to 4 mile spacing. Can you walk the board through this?
Yeah, so these are the ones that we kind of started spacing last year, starting with the red box and cause number 130-39, and then we've kind of added on to other 4 mile units since then.
Okay. And one notation over here, there's a box that's in green. The order in cause 130-46 has been approved and entered recently. Can you confirm that?
By the time when we put these exhibits together, it had not been approved yet, so that's why it says approval anticipation, but it has now been approved.
Okay. Exhibit 9?
Exhibit 9 shows the requested 4 mile units that we'd like to add to our 4 mile spacing today.
And so it's just these in red.
These 2, yeah. Do you want me to read the sections?
Nope. I'm fine with it, but maybe the board. I think we're good. Okay. Exhibit 10.
And Exhibit 10 is the existing lease line spacing units for 4 mile development.
Okay. And it is confusing. I know in an earlier hearing they submitted several exhibits with the number of overlapping section line wells. It would be a lot of exhibits. So if there's a need for clarity when we submit these, please let us know and we're happy to comply.
Actually, you got 20 exhibits. You got plenty of exhibits. So.
Thank you. Thank you. Exhibit 11.
Exhibit 11, this shows our what we're requesting for the lease line well spacing units for our 4 mile development today.
Okay. So really, out of all these, Exhibit 9 and Exhibit 11 are going to show them the units that you're looking to have the board establish.
That's what we're doing today, yes.
Okay. Now, there were some questions earlier, and I don't necessarily need you to testify about it, but I want to let the board know. There were questions in the earlier pooling matters from the hearing examiner about the application of overlapping drilling to poolings. These exhibits are here, and the witnesses are here. If there are further questions, just like to invite all to explore any concerns they have with those. Before I let you go, Mr. Harris, that's the end of your substantive exhibits. Briefly talk about notice. How did you guys notice people? Who did you notice? that kind of stuff.
So we have new title opinions covering those sections so that we got the names and the searched addresses for them. And then on the offsets, we use existing revenue decks that we had in the area and supplemented with landman brokers where we needed to.
Okay. And have you seen what's been filed as the certificate of service or
Yes.
certificate of mailing in this cause?
Yes.
And can you confirm for the record that the names included on the certificate of service represent all the owners who received notice in this cause?
Yes.
With that, I have nothing further for Mr. Harris, subject to division or board questioning.
Division?
Thank you. Just a question on the slide we have here right now. You talked about how you're going through and spacing all this. As you can see, there's a gap. I think that's sections 19 through 22, and then on top. Is there any reason that those aren't being spaced for 4 miles right now?
To the north, we haven't determined how we want to develop that horizontally yet. And then in the 19, 20, 21, 22, there's existing horizontal wells right there. So that's also not up for 4 mile development at this time.
All right, thank you. No further questions from the division.
Okay. Board members, any questions? I don't see any. Go ahead.
Thank you. Before I let him go, I forgot to ask him the key question. In your expert opinion, do you believe that the request is protective of correlative rights and will maximize resource recovery?
I do.
Okay. Thank you.
Thank you.
With that, I will bring up Ms. Ross for her testimony. Would you please state your name and confirm your business address for the record?
Yes, Katie Ross, 1700 Lincoln Street, Suite 3200, Denver, Colorado 80203.
Okay. And what is your current position with SM?
I'm an asset geology manager. Work in Utah.
Okay. And I'm assuming that has a supervisory role over the geology associated records in the subject lands?
Correct.
Okay. I'd like to remind all Ms. Ross will be testifying as an expert in geology and geoscience, and turn to your exhibits. Exhibits 12, 13, and 18. Do you recognize those three exhibits?
I do.
And were they prepared by you or by SM personnel or contractors under your control or supervision?
They were.
Okay. Exhibit 12. Walk the board through this and what it shows.
Yeah, so this is a type log for the area. We're on our western arm of the acreage that Rick pointed out. On our western township, this is the Lake Fork Ranch. The bottom gamma ray track is colored more or less to infer lithology, where the grays are more your shales or your mud rocks. The yellows would be your sandstones, and then the cleaner portions and the blues would be more of the carbonate lithofacies. And then at the top up there, you have resistivity, where we have resistivity greater than 15 ohms highlighted in red. And that's generally inferred where you have organics or hydrocarbons in the system. And at the very top, you've got the Uinta, Upper Green River, Lower Green River, Wasatch, and Flagstaff members of our stack.
Okay. Thank you for that. Exhibit 13.
Yeah, this is a cross-section that is as close as we can get to the lands that we're discussing today. With the best quality logs that we have here. Again, you'll see the Lake Fork Ranch on the left, very, very similar logs here as well. The third column that you have over there in green and in blue is in our interpretation of where oil is saturated in green, or hydrocarbons, and in blue would be where water is filling the pore space. And it's going from the Lake Fork to the Marin all the way to the Sonat Strand across our main townships, or the principal acreage that we're developing right now.
Okay, a couple follow-up questions if I could.
Mm-hmm.
You mentioned the Lake Fork. Just confirm that's the same as the type log well?
Correct.
Type well?
Mm-hmm.
And second, you mentioned this is the closest. There aren't any wells for the cross-section that penetrate the subject lands or produce from the subject lands. And you mentioned the best quality data from the logs. Can you just kind of talk about that?
I can expand on that. So these are the most continuous logs. You have other wells that penetrate, but they're pulsed or partial quality, and these are the ones that we feel the most confident in, and they're close enough and adjacent to the land, so we feel they represent the rock types here.
Perfect. Thank you for that clarification. Finally, turning to Exhibit 18.
Yeah, so this is, we discussed this as well as last month. This is with the data that we have in hand right now at SM, our SH Max interpretations here would confirm that a laydown orientation is the most beneficial development schematic for our company to make sure that we stimulate the rock as effectively as possible and don't have any waste.
Okay. Thank you for that. Before I let you go, is it in consideration of your exhibits 12, 13, and 18, is it your expert opinion that the request here is the best way to protect relative rights and maximize resource recovery while preventing waste?
Yes.
Okay. Thank you.
Excuse me.
No further questions subject to the division and board examination.
Division?
Thank you. Division has no questions with Mr. Ross. Thank you.
Okay. Board, any questions?
Yeah, I have a quick one. Back to exhibit. Yeah, I think it's the next one. 13.
That one? Okay.
When you speak about the saturated zones
Mm-hmm.
in blue, how are you addressing the water there?
Yeah, so that's a calculation our petrophysicists calculate from the resistivity. Is an Archie's equation, and we calibrate that to core so we can get a percentage of how much we interpret to be saturated with water, and then you subtract that from our analysis, and then you get an idea of how much hydrocarbon is there, and that's what we place in green.
And as you're extracting the water, I'm just wondering what you're going to do with the water.
What are we going to do with the water?
It's saturated?
Yes, you develop all the fluids, correct?
Okay.
Yeah.
Right,
Basically, are you asking post-production plans for the produced water?
Uh-huh.
We use it.
Okay.
Yeah, we reuse it substantially in Utah.
Just a quick question. The SH, what does the H stand for?
Horizontal.
SH max. Okay.
It's the horizontal.
Stress
direction.
horizontal.
Stress horizontal, correct.
Max.
Yes,
Okay.
SH max. Sorry, I can clarify that.
I've been doing this for 12 years. I didn't know that.
Okay, good. Thank you, Mr. Mayo.
Thank you.
Thank you. The last witness of the day, Mr. Brad Peterson. Mr. Peterson, could you please state your name and business address for the record?
Yes, it's Brad Peterson, 1700 Lincoln Street, Suite 3200, Denver, Colorado, 80203.
Okay. And you were responsible for submitting, and I'm going to scan through them quickly, exhibits 14 through 17 and 19 through 21. Do you recognize those exhibits?
Yes.
And were they prepared by you or SM personnel or contractors under your direction or supervision?
Yes.
Okay. I'm not even sure which of these you would like to address necessarily. I know not all of them are purely probative here today. So why don't you tell me if this is something, the Uinta development history is something that's relevant for the hearing?
Yeah, I'll just cover them pretty high level fairly quickly. So this is just a production plot, again, showing our growth in the basin. Currently, we do have the 3 rigs currently running, and as well as a continuous frac crew. As you can see, oil production went up over close to 75,000 barrels, and we've kind of dropped back down at about 55,000 barrels a day. We'll continue to flatten out that decline as we bring on more wells this year. So if we go to the next slide, really this continues to show the execution that the great execution that we've had on the 20K laterals. At the time of making this slide, we had the 4 wells that you can see in the plot there. Initially, we had planned to drill laterals in roughly 30 days, and you can see all those days that those wells were executed, in less than the planned lateral length. We currently have, 3 rigs have been drilling on all the pads. This slide currently says there's 10 more planned. As of today, we've got three remaining. So continue to go through them, drilling them, and really positive execution so far.
Okay. Thank you.
This next slide really kind of outlines, really why we kind of had to rush this one through. As Katie showed previously on the stress, Our view of the stress with additional technical data shifted that where we should lay down wells versus stand up approximately 2 miles to the east. Yeah, so really what we're doing here is we're going to develop these as 4-mile laterals. There's also a secondary benefit. As you can see there on the bottom plot, or actually in both plots on the right, there's an existing well. The top plot shows the previous plan that we do have drilling permits in place for. The lower plot is what we're really needing to kind of get this one rushed through to get approval on. And what it does is kind of two things with the additional view and the stress shifting a little bit to the east. It sets us up to be able to drill those existing or the remaining development in the upper cube at 4 miles, as well as drill in between depletion at the longer lateral length. As you can see, the one horizontal that's in the Jurassic Park and DSU there. So it kind of does a couple things. We are planning to move the rig onto the Braveheart pad, which is the pad that would contain these 3 wells here in about 3 to 4 weeks. They will be planned as the last wells on the pad. So there are a little ways out, but that's really kind of with the changes and what we're going to be doing for optimizing the development here.
So you mentioned, and maybe this is probably important to discuss, but the need for overlapping units is real because there's spots where a 2-mile well makes the most sense in your current development, and spots where a 4-mile well makes the most sense in your current development. Is that kind of what this shows?
Yeah, and as you see on the bottom slide on the right there is exactly that. So the northernmost well is going to be a 2-mile well, and then there'll be 3 4-mile wells, and then the rest of the unit will be developed with 2-mile wells. So yeah, mixed bag of those different lateral lengths to really optimize drainage and development for the acreage.
Okay. That is helpful. Let's move on to exhibit.
Yeah, and I'm not going to cover this in too much detail. We've talked about this quite a bit. I think, bottom line, with the commodity prices fluctuating lower recently, drilling long laterals allows us to be more efficient in developing the acreage, both economically as well as minimizing surface disturbance and surface locations out here in the basin. So the combination of both the economic and less surface impacts really drives the benefit for long laterals. And we've been very, very successful so far on execution through the drilling phase on all the 4-milers. And then we've just recently, in the last month or so, started putting on our 3-mile wells, and everything seems to be looking really good there. So, continuing to develop at these long laterals, and we don't see anything that, has us have any concerns.
Okay. 19, 20, and 21. You talk about this?
Yeah, so the next couple of plots really get back to the 100-foot setbacks. So this first plot is really an update of our estimates.
Let me jump in real quick and just interrupt. The units that are established, the 2-mile and 3-mile horizontal units, those are subject to 100-foot heel toe setbacks already.
Yes, that's correct.
So this is just essentially justifying a continuation of the 100-foot setbacks for these units.
Yeah, that's correct.
Okay. Now go ahead. Sorry.
So the maps on the left there are both our porosity maps for both the upper cube and the lower cube. And then the upper plot is really a porosity versus permeability. And so you can see for the upper and the lower cube kind of how we get from kind of porosity for the development of these to permeability estimates. And the estimates are they're shown on the right. And then really the last thing is a summary of our PVT that we've gotten. So this is in situ viscosity for the lower cube in blue and then the upper cube in green. shallower you go in section, the higher the viscosity, also the lower kind of pressure you get, pressure gradient. So you can really see, this is where we, got the data to plug into the Hale and Evers calculations on the next couple slides. At a real high level, we had previously got the 100-foot setbacks for both the 2 and the 3 miles, as Mitch said. With our updated geological and fluid properties, the estimate, for this gets us to, really after 10 years, about 26 feet from the line. And then in the next one gets us to roughly about 10 feet using those geological and reservoir parameters. So,
And those Hale and Evers calculations or models, those how closely aligned with SM's internal models would you say those are? Is it match kind of what you come up with on your own internal modeling?
Yeah, I don't have any technical concern of drainage due to the 100-foot setbacks.
Okay, thank you. In your expert opinion, based on your exhibits presented here today, do you believe the request is fair and reasonable and protects correlative rights while maximizing resource recovery?
Yes, I do.
Okay. No further questions for Mr. Peterson, subject to the division and board questioning.
Okay, division.
Thank you. The division has no questions for Mr. Peterson. Thank you.
Okay, board, any questions?
So on this slide right here, where's the years? How many years out?
Time and hours, and then that's just converted to days there.
Oh, okay, that would be 10 years.
Yeah.
Board, do you guys have any other questions? Not seeing any.
With that, I'm done with my presentation, my case in chief, and it's probably appropriate for me to move for admission of the exhibits 1 through 21 inclusive.
Oh, yes, there's one. Got it.
Ask the division if they object.
Yep. Division, any objections,
No objections.
concerns? Okay.
And I don't know if the division has a case in chief. I'm happy to present my summation now or wait till they're done.
Division.
No case in chief. Just want to indicate, as Mr. Mayor said, the division filed a. I don't know if that's me. I don't know. The division filed a notice of non-opposition on February 10th, 2026. After reviewing the request and the exhibits and listening to the testimony here today, the division continues to have no opposition to the granting of this request. Thank you.
Okay. Go ahead, Mr. Mayo.
Thank you. With that, we do believe this is a very reasonable and common sense extension of what's been proven successful in SM's operated acreage. We also believe all the regulatory and statutory requirements have been met, and with that, we'd request you approve it. Before I submit, though, I'd like to thank the board and the division. This was one we filed after the filing deadline through no fault of our own, and it's a real testament to the board and division's ability to work these emergency matters through when they can. So we appreciate that.
Okay.
And with that, I'm done.
Okay, thank you. So, board, any need to deliberate this? Okay, it looks like you want to make a comment, Mr. Mayor.
Yeah, comment and a motion. So I wanted to express our appreciation to SM Energy. You're leading the way with 4-mile horizontal wells. With your expertise from other basins, that's just helping us. It's helping other operators, and just doing a good job. I know it's getting harder to find locations. I'm hearing more and more from neighbors. It's tough. Hang in there. Just encourage you to treat our landowners as well as you can. I know that you have budgets. But just want to encourage that and just appreciate what you're doing. So with that, I'd make a motion that we approve this request for agency action.
I'll second.
Motion's been made and seconded to approve the request for agency action. All those in favor say aye.
Aye.
All those opposed say nay. Let the record show that it's unanimous. Also want to thank the witnesses for coming over here personally. We certainly appreciate your time coming over here and like seeing you and all that, so very much appreciated. With that, I think we're done.
Mr. Chairman, I'm happy to prepare the
Oh,
order.
yes,
I know there's
okay, sorry,
for-
almost done.
The good news
Please
is
prepare the order and have it ready in a week.
I'm happy to do that. We're in probably a bigger hurry than the board, so I've got a draft order. I'm going to try and finalize today and get moving through the process. But
Okay,
we'll do that.
cool. Thank you very much.
Thank you.
With that, let's have a motion to adjourn.
So moved.
Any second or any objection? All opposed, say nay. No. Okay, thank you. We're off the record. We are adjourned.